Have y'all had a hearing last?
We try to avoid them.
Maybe that's why I haven't met y'all.
Well, good morning. It's Thursday, January 31st, 2013. It's now 9:15 a.m. The first order of business today is we're going to dispense with our normal approval of items so that we may go into the formal hearing we have this morning. So at this point, I will turn the formal hearing over to our judge.
Thank you, Mr. Chair. Y'all, is that working? I guess it doesn't. It just absorbs the sound. It doesn't actually magnify. All right. Sorry. Well, I'll talk slower for you. Good morning. I'm Judge Collier, the administrative judge assigned by the Secretary of State's office to preside over this hearing, sitting with the State Board of Examiners for Land Surveyors. Are you Mr. Atchison?
Yes, ma'am.
Good morning. You are the respondent in the case of the Tennessee Department of Commerce and Insurance versus Devin R. Atchison, which is docket number 12.11-119407A. And I assume, since no one is with you, that you've chosen not to be represented by counsel in this morning's hearing?
I cannot.
Okay. You are allowed to represent yourself, but I wanted to make sure you understand.
There's nothing I'm contesting. I'm here because I was.
All right. But like I said, I just want to make sure you understood you do have the right to have an attorney if you'd like to.
Yes, Your Honor.
All right, good. And Mr. Joseph, I'll let you introduce yourself for the record.
Thank you, Your Honor. My name is Jesse D. Joseph, Assistant General Counsel in the Litigation Division for the Department on behalf of the state.
Thank you. And members of the board, I know we've got your name tags, but for the purposes of the hearing record, if I could have each of you introduce yourselves as well, please.
My name is Galen Northcutt.
Tim Lingerfeld.
Sue Brawley. Thank you. This morning, I will make all of the rulings regarding the order of proceedings, the admissibility of evidence, and the questions of law under the authority granted to me by the Tennessee Administrative Procedures Act. I will not participate in the findings of fact or the ultimate decision. That will be the Commission's job to do this morning. And Mr. Joseph, do you have a notice, a copy of the notice of hearing and charges to pass to the board members? Sir. If you'd like to do that at this time.
Thank you.
Members of the board, there are 3 documents in my file so far. The first one is the notice of hearing and charges. That was filed in my office on December 17th of 2012. That's the document Mr. Joseph is passing to you at this time. Second document I have in the record is an order I issued on January the 8th of 2013, and that set forth the pre-hearing deadlines for today's contested case hearing. Third document in the technical record is the state's list of witnesses and exhibits that was filed on January the 22nd of 2013. Mr. Atchison, I did not receive a witness and exhibit list from you. Did you plan to have anyone other than yourself testify? All right, thank you. Members of the board, I'll remind you that during the hearing, there should be no discussion concerning the case other than that is held here in the room on the record. During the hearing, you all will sit essentially as a jury, and you must consider only the evidence introduced during the hearing. The state sunshine law requires that all boards and commission discussions and deliberations be made in public before all parties. Failure to comply with that requirement could result in the board's action being reversed or remanded if appealed to a higher level court. You should not draw any conclusions until all of the proof has been submitted, and you should listen openly to all proof no matter from which side it is submitted. Are there any preliminary motions, Mr. Joseph?
No, I don't have any preliminary motions, Your Honor.
All right. And members of the board, have you all had a chance to review the notice of hearing and charges? I'll give you a minute.
Just give us a minute, Your
I
Honor,
will.
if you may, please. I think we've all reviewed your honor.
Thank you, Mr. Chairman. Members of the board, the law requires you to disclose on the record any outside knowledge of this case or any communications, written, verbal, or otherwise, from any of the parties concerning this case that you have received. Any of you have any prior knowledge? All right, thank you. Mr. Joseph, would you like to begin with an opening statement?
Yes, Your Honor. We're going to swear witnesses now after I finish.
We'll do it. I'll just do it
All right.
each individually. Do you have more than one? How
I
many
have one witness as a possible rebuttal, Mr. Herndon, but I have one for the primary witness, Ms. Moulder.
Okay.
Thank you, Your Honor, members of the board. This is a notice of hearing the charges filed against the respondent, Von R. Atchison, based on the respondent's refusal over perhaps what is now a 2.5-year period to comply with the provisions of a prior disciplinary order of this board, which was entered in September of 2010. The state's proof will show that the respondent was first registered as a registered land surveyor in 1997 and that his registration is currently scheduled to expire in December 31st of this year. The proof will also show that in a prior complaint, the respondent signed and consented to the entry of a consent order in case number 2010-000621, which was entered by this board on September the 16th of 2010, wherein the respondent was assessed a $1,000 civil penalty and was required to take and complete 8 hours of continuing education courses on the subject of ethics. This consent order allowed the respondent to pay the $1,000 civil penalty in 13 monthly installments of $75 each, with a final installment of $25, and with the first monthly installment payment being due on September the 30th, 2010. According to this schedule, the respondent should have completed payment of the civil penalty by November the 30th of 2011, 14 months ago. The proof will only show that the respondent has only made one payment of $150 toward this $1,000 civil penalty. That one payment, by the way, was late, and that this $150 payment was received on November the 17th of 2010. The payment schedule set up in this agreed order was very liberal, very reasonable, and certainly not burdensome, and the respondent agreed to it in writing. The proof will also show that after September of 2010, the respondent has never presented to the board's administrative staff evidence that he has completed the required 8 hours of ethics courses. The proof will be clear, and we believe undisputed, that the respondent has violated provisions of a board order to which he's a party. After consideration of all the proof, the state requests the board to find that the respondent has violated Tennessee Code annotated 6218.116A1B in that he has engaged in misconduct, and that he has engaged in the subsection a violation of 6218.118A1C, which is any violation of this chapter or the rules of this board. Further, the board is empowered pursuant to its own rules, 0820-4-.07, to consider other actions, such as the action the respondent has committed herein, to constitute misconduct. Further, the respondent's failure to comply with this prior consent order authorizes the imposition of additional civil penalties, according to Rule 0820-1-.061K, which sets forth that the board may impose civil penalties for each separate violation of a board order in the amount of between $100 to $1,000 per violation. Each day could constitute a separate violation according to the board's rules. The state considers that the respondent's actions in this case have disrespected the authority of this board and this profession, and we would request the board after consideration of all of the proof, to suspend the respondent's registered land certificate for a minimum of a 6-month period, that he remains suspended indefinitely until he pays in full the $850 civil penalty balance on September 10th, September of 2010 consent order, and additionally that the board assess a separate civil penalty for violating the order of $1,000 for his violation of this civil consent order over the past 14 months. And finally, that he remains suspended until he submits documentary evidence to the staff that he's completed the required 8 hours of continuing education and ethics. The state would also request that the board in its final order assess the cost of this cause, including the cost of the Administrative Procedure Division and the cost of the court reporter against the respondent, and we would submit that the policy rationale for entering such an order should be that it is necessary to protect the interests of the citizens of this state and to uphold the regulations of this profession. Thank you.
Thank you, Mr. Joseph. Mr. Atchison, would you like to make an opening argument? Thank you. Mr. Joseph, who would you like to call as the state's first witness?
We would call as our first witness, Your Honor, Ms. Donna Mulder.
Ms. Mulder, I think it'd be all right if you stay where you are. Okay. If you would, though, please raise your right hand. Do you swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth? I do. Thank you. Go ahead, Mr. Joseph.
Your Honor, before I begin examining Ms. Mulder, I have a request to enter into evidence as Exhibit 1 a copy of the state's certified mail return receipt on the notice of hearing and charges, which I do not believe there will be any objection to. We do realize that the respondent's here. Certainly there's no default, but we want the record to reflect that we serve the respondent with this notice of hearing and charges at least 30 days prior to the date of this hearing.
That'd be fine.
And we ask that this be marked and entered into evidence as Exhibit number 1.
You've pre-marked it, so this notice of hearing copy has been marked as Exhibit number 1, will be entered into evidence as such. You may pass copies to the board.
Could you please state your full name for the record, ma'am?
Donna Mulder.
What is your business address, Ms. Mulder?
500 James Robinson Parkway, Nashville, Tennessee.
Are you an employee of the Department of Commerce and Insurance?
I am.
And how long have you been an employee of this department?
25 years.
What is your title, ma'am?
Administrative Director.
And what are the department's regulatory boards and commissions that you act as administrative director for?
Land Surveyors, Professional Geologists, and Professional Soil Scientists.
What was the last one?
Soil Scientists.
Thank you.
Generally, Ms. Mulder, what are your duties as administrative director for this board?
I am the custodian of the records and books of the Tennessee Land Surveyors Board, and I am responsible for the licensing and renewals of Tennessee licensed land surveyors.
Are you familiar with the respondent in this matter, Devon R. Atchison?
As a licensee, I am.
When was the respondent first registered as a registered land surveyor by this board?
February 26, 1997.
And when is his certificate of registration currently scheduled to expire now?
December 31st, 2013.
What is the respondent's certificate of registration number?
1867.
Are you aware of a disciplinary sanction in the form of a consent order that was entered by this board against the respondent in September of 2010?
I am.
It's a copy of the document which I just presented to you, a copy of that consent order signed by the respondent in September of 2010, case number 2010-000621.
It is.
Do you maintain a true and correct copy of this consent order signed by the respondent within the official books and records of the board?
I do.
Do you you have a business duty to do so?
I do.
Did you execute a certificate to the effect that this document is a certified copy of a public record on the 23rd of January this year?
I did.
Thank you. Your Honor, we would ask to be admitted as exhibit number 2, a certified copy of the September 2010 consent order entered against the respondent.
All right, the September 2010 consent order has been pre-marked as a certified copy. It's pre-marked as exhibit number 2. It will be entered into evidence as exhibit number 2, and you may pass copies to the board.
Thank you. What was the respondent required to do, Ms. Mulder, according to this consent order?
Pay $1,000 civil penalty and complete, show proof he's completed 8 hours of continuing education on ethics.
And what were the payment terms of this order?
13 monthly installments of $75 and 1 monthly installment of $25.
Did your office ever receive any payment whatsoever toward this civil penalty from the respondent?
Yes. We got a check on November 17, 2010 for $150, which was 2 payments.
Did the department process that payment?
They did. They did.
Okay. There's a copy of the document which I'm just showing you now, a copy of the respondent's check to this department on November 10, 2010 for $150. His handwritten note sent with that check, as well as a copy of the department's fiscal receipt setting forth that it was processed on November 10, 17, 2010.
It is.
Do you maintain a true and correct copy of these documents within your official licensing and complaint files regarding this matter?
We did.
And do you have a business duty to so maintain?
I did.
Your Honor, we ask that this document, which we'll call a collective exhibit because it's 3 pieces, the respondent's check toward the civil penalty dated November 10, 2010, his handwritten note to the department setting forth his monthly payments, and the department's payment receipt be all entered into evidence as collective exhibit number 3.
All right, those documents have been marked as exhibit number 3, and they will be entered into evidence as such. You may pass copies of exhibit 3 to the board.
Thank you, Your Honor.
Watch out. You don't need acrobats.
That's right.
This wasn't designed for the walkthrough.
Exactly right. Since November of 2010, Ms. Mulder, has your office received any further payments from the respondent as to the $850 balance which is owed on the civil penalty?
We have not.
After the effective date of this order, which was September of 2010, has your office received any documentary evidence from the respondent indicating that he has completed the required 8 continuing education hours in the area of ethics?
We have not.
Have you ever told the respondent, either orally or in writing, that he would be allowed by the board to have an ethics course he completed in December of 2009, given retroactive credit to satisfy the educational requirements of this order?
No, I have not.
Would it be customary for your office to ever give a respondent this type of advice?
No,
And why is that?
because we're not authorized.
Did your office, have you had any communication whatsoever from the respondent relative to his obligations to comply with this order since November of 2010?
No.
Thank you. No further questions at this point.
Thank you, Mr. Joseph. Mr. Atchison, do you have any questions for Ms. Mulder? All right. Mr. Chairman, do you or other members of the board have any questions for Ms. Mulder? Thank you, Ms. Moulton. Mr. Joseph, would you like to comment?
Your Honor, we have a rebuttal witness if necessary and possible rebuttal proof, but at this juncture, we'll turn the matter over to the respondent for his point of view.
All right, thank you. Mr. Atchison, please raise your right hand. Do you swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth? Please state your complete name for the record. Thank you. At this time, it's your opportunity to present any testimony that you would like to the board regarding this matter. Since you're representing yourself, you just may testify in a narrative format. You don't have to actually ask yourself questions.
I don't know what to say. I will mention the matter, but I would like to state feelings on the matter. This complaint that was the initial beginning of this, I was very disappointed that I did not get to appear before the board. This is a decision made by the board and offered to me, and I was able to take it.
I'd be more than allowed to testify in a narrative fashion, but I would ask if the court please that the respondent related to matters that are properly before it. This consent order includes that prior complaint, and this is a litigated matter. I mean, this is a concluded matter, so to reopen and discuss the merits of that complaint, we don't think would be appropriate because that was included by this consent order. And to the extent that this consent order says that the respondent made on procedures he could have had a hearing. I just don't know if that testimony is appropriate at this time. This consent order speaks for itself.
Mr. Atchison, the proceedings today are about a complaint that you violated the consent order.
I understand. I was just getting to what I was.
I'm going to give you a little bit of leeway, but his objection is valid. We're not going to relitigate the earlier
There
case.
is nothing that could be done about it. I was just stating for the fact that this was what I was presented with, and at the time I intended to fulfill this obligation. Unfortunately, after the passing of my wife and the loss of her income and the depletion of all our savings plus more money for the battle of cancer, I became very poor. I had also closed my business in 2005 and gone to work for a couple other employers. And in 2008, when the economy crashed, the business crashed, being the last one hired, one of the first people laid off, attempted to go back to private practice, which had been closed for 3 years. I was not making a lot of money, and I had some debt and a lot of savings. I became very, very poor. Subsequently, I lost both of my vehicles, and I lost my house. I have done 4 survey jobs since 2002. One of the last ones was the job mentioned in the complaint where this matter came before the board, where a person filed a complaint and it was dismissed. Now I work, I receive Social Security, a small amount. I am obligated to pay interest on back child support, which the child support has been paid for years on the California order where my ex-wife will not sign off. So I'm deducted out of my savings, and I finally, after a year and a half, 2 years of looking, was able to land a minimum wage job. I'm 64 years old, and I'm going to take home about $270 a week. I cannot contest this. I cannot pay the fines. To solve this matter right now, I have no defense. I mean, I'm here, as I said, because the charges have been filed. I have to appear. I'm not contesting them. It's a matter of plain fact.
Thank you, Mr. Atchison. Mr. Joseph, do you have any questions for Mr. Atchison?
You did sign this consent order, correct?
Yes, sir. Yes, Mr. Justice.
You understood what the terms were?
Yes, I fully intended to take care of them, but at the time, situations changed, and the thing in what happened to my life, I desperately tried to maintain my life after the loss of her income and costs incurred fighting her cancer, depletion of my savings, and the lack of work. I didn't intentionally say I'm just going to ignore it.
But you understand, do you not, that the provisions of this board's consent order, and you are a licensee,
Yes.
that this is similar to a contract, correct?
I'm quite aware. In fact, I said I am not disputing it. I mean, I came because, like I said, I was bored here. I'm here. In fact, like all charges in there are correct. I do not dispute anything that letter says. I'm just saying that it's not intentional. I put a rock on a hard place, and all my efforts to take care of the matter and sustain my life actually fell down the toilet. And this is the last thing besides my life I've got to lose. I lost my car, my house, my property, everything else. $1,038 this year. I was at $1,090. Out of that, $375 automatically paid to the state of California on interest, not on child, on interest back on which there is no way God or I can make.
Out of that over $1,000 a month on the Social Security payment, you were making the Social Security you signed to settle, correct?
I was receiving 500. I was receiving her death benefit. I was 60 years old.
This was 2.5 years. 64 years old now.
It was 2000.
September of 2010. How old were you in September 2010?
I'm trying to remember. I was born in 1948, December. She died in 2010. I was 61 years old. She died in May, so in December 2010, I turned 61.
But after you began to receive this over $1,000 a month in Social Security benefits, you realized that your obligations under this consent order were only to pay $75 a month, correct?
Yeah, I was paying a payment on my house, which I had for 15 years. I was paying payment on a vehicle. My only vehicle that I had, because I had to sell her vehicle upon her death.
Why did you continue paying $75 a month to this board?
Because I went in the hole every month. That's why, like I said, I'm almost 65 when I'm working at a $7.52 an hour job. I'm thankful I have.
No further questions, Your Honor.
Thank you, Mr. Joseph. Mr. Chairman, members of the board, do you all have any questions for Mr. Atchison? Thank you. Mr. Atchison, anything else you would like to add at this time?
No, I just want to know that I'm not trying to be disrespectful or rude or anything. I'm just, as I said, I'm willing to admit that I'm in violation of the order. I apologize to the board. It's not intentional. And I'll take whatever you decide is punishment. Face it. I should come up with even $850 right now. I mean, I had to borrow money just to buy gas to get it, and I'm losing $64 in salary paid, which we can collect I don't expect it to grind or anything. It's just an honest statement. We're supposed to, when we get old, be taken care of. We like to treat you that way. I do apologize to the board for violating. That's all I'd like to say.
Thank you, Mr. Ashton. Mr. Joseph, any additional proof from the state?
Your Honor, we don't have any additional.
All right, would you like to make a closing argument?
Your Honor, I think I've gone on long enough. I don't want to overly tire the board. I will waive any further oral argument in the matter of sending this matter to the board on our here to submit to the board and present the matter for the board's consideration and their disposition.
Thank you. Mr. Atchison, would you like to make a closing argument?
No.
Thank you. Members of the board, you have now heard the proof in the matter of the Tennessee Department of Commerce and Insurance versus Devin R. Atchison, which is docket number 12.11-119407A. It is now my duty to charge you as to the law you must follow in reaching your decision. You are the exclusive judges of the facts in this case. You are also the exclusive judges of the law, specifically your statutes, rules, and regulations, and their application to this case. You should apply the law to the facts in deciding this case under the directions of my charge. You exclusively have the authority to make findings of fact and reach conclusions of law in this matter. No one else can participate in your deliberations. However, if you find that you need to have the law or legal terminology explained to you, I can assist you. The state has alleged that the respondent has violated certain of the state's applicable statutes and rules. It is the state's burden to prove those allegations by a preponderance of the evidence. Do not confuse this standard with the higher standard of beyond a reasonable doubt used in criminal court proceedings. A preponderance of the evidence means the greater weight of the evidence, or that there is sufficient proven information to cause you to believe that the state's allegations provide the more probable conclusion based upon all of the evidence presented. You must limit your inquiry into violations of rules and statutes to those that were specifically alleged in the state's notice of charges, which was passed to you at the beginning of the hearing. And you must base your determination solely on the evidence presented to you during today's hearing. The evidence consists of the testimony as well as the documents that were admitted into evidence during the hearing. The notice of charges and the proposed order that Mr. Joseph plans to present to you in a moment are not evidence. You may consider these arguments and documents to assist you in making your findings of fact and conclusions of law, but you should do so only after careful consideration and a determination that they accurately reflect your own independent recollection of the evidence and your own conclusions from the evidence. You should always keep in mind that the state bears the burden of proving the charges. The respondent does not have the burden of proving that he or she is innocent. The Administrative Procedures Act specifically requires that your order contain 4 sections. Number 1, findings of fact. Number 2, conclusions of law. Number 3, a decision regarding what disciplinary action shall be taken, if any. And number 4, the policy reason for your decision and determination. In making your findings of fact, you must make your own evaluation of the testimony given by each of the witnesses and any documentary evidence admitted. You must then give that testimony or other evidence the weight and credibility that you deem proper. You may weigh the evidence in light of your own training and expertise. Once you have made your findings of fact, you must decide if the respondent's activity constitutes a violation of departmental or board rules or state statutes as alleged in the notice of charges. And if so, you must state those determinations in your conclusions of law portion of your order. Your decision must include sufficient analysis of the evidence to clearly demonstrate how the facts of the case support your conclusions. Your conclusions of law should make appropriate specific references to your findings of fact to articulate linkages and connections between the 2 sections of your final order. If you decide that there has been a violation of a state statute, rule, or previous order, you must then decide what disciplinary action is appropriate in accordance with your legal authority and considering the particular circumstances of this case. You may consider any evidence that the parties have introduced on the issue of the appropriate disciplinary action, including whether the conduct allegedly was or is of a continuing nature or is a one-time offense. Additionally, you may also consider what you have done in previous similar cases. Under the law, administrative agencies are not required to have absolute consistency in the disciplinary action they take. However, this does not mean that you may be arbitrary and capricious in dealing out disciplinary sanctions. Disciplinary actions must be based on fairness and reason. Finally, your order shall include a policy reason, which must accompany your determination and state why the decision you render in this situation is appropriate. Your policy reason is a statement explaining why the particular disciplinary action you choose in this case is correct, given the wide range of cases you hear and the various disciplinary options you have. Your deliberations must be in public before all parties. If you need assistance with the law or the structure of your order, I will be available to assist you. If you have any questions about the facts presented, you may, by a majority vote, reopen the record and hear additional proof or further testimony from the witnesses and or argument from counsel. And Mr. Joseph, I believe you said you had a proposed order? All right. Pass copies to the board, please, sir. That, members of the board, this proposed order will be entered into the technical record as technical record entry number 4. You may consider the proposed order that Mr. Joseph has just passed to you as you make your determination. Remember, you are not bound by the parties' proposed findings and conclusions. Instead, these have only been submitted as a guideline as to what counsel for the state thinks the proof has shown. It is up to you to determine what has actually been proven and choose any disciplinary action that you think is appropriate. Unless there is an objection from counsel or Mr. Atchison at this time regarding the charge, I will now turn the hearing over to the board chairperson to preside over your deliberations, after which you will make findings of fact, reach conclusions of law, including a decision regarding whether any disciplinary action shall be taken, and if so, determine what disciplinary action shall be taken, and give your policy reason for your decision. Mr. Chairman?
Thank you, Your Honor. As the members review the findings of fact, I think they're pretty well what we saw already, and the conclusions of law. I think those continue to be the same as they were. I personally would like to say that I'm very sympathetic to Mr. Atchison's plight and the personal issues that he's had to deal with over this time period. However, the fact remains that an order was issued, it was agreed upon, and has been violated. Again, in listening to what Mr. Atchison has said, from my purview, where I sit, it seems that if the gentleman is currently having financial issues, that the likelihood of, by assumption, that he would renew his license at the end of 2013 may be remote. My recommendation to the members, and we'll certainly discuss this, would be, I don't know if it's appropriate with the way Mr. Joseph has presented the proposed judgment or not. We're in the discussionary stage. My recommendation is that we would petition the respondent for voluntary surrender of his license and conclude the matter at that point. I don't know what the members feel like on that issue. That's obviously within the confines of the conclusions of law that we have to do under 62-18-116. We can deny, suspend, or revoke, and voluntary surrender, in my mind, is a parallel to revocation. By my definition. So that's my thoughts. but it would have been last year. But is it also for South Florida?
Even though I don't, I'm using my license, spending money for continuing education. Somebody's unfortunate, I gave him, with enough money to continue serving. I wouldn't want to have to go through the process that we did. I'm applying for a license. Quite frankly, at my age and my physical health, I don't know if I'm going to survey anymore or not. It's to the point where the economy, unless you're a big established firm, small-time older surveyors, it's rough. There is very little work, and the bigger companies are looking for young college grads that they can pay little money and keep on another guy half a year. So the old-time people have been around, and it's, I mean, at seminars and stuff, the attitude of a lot of surveyors is that it's just like we've been put out to pasture in a field that is, I hate to say it, kind of done itself in by some of the things they've done, and we're just being GIS and the fact that anybody thinks they can go out with equipment and survey without knowing anything. We can just put in the back burner is not a necessity longer. I mean, you don't find people having a property surveyed anymore unless there's a real legit need for it. And that's just, there's just my experiences. I don't know what to say about it. It's just that that's the way it is. And unfortunately, younger surveyors are not coming out. Most surveyors, the majority of them are old. And there aren't very many new ones coming out. It's just because of the fact that all the time, effort, and money you have to put into it, and the grief that you have to do because of the strictness of the ethics, and the fact that people lie to you and try to deceive you all the time, it's not worth it. You could do something else and make a lot more money. It's just a thing. I've been in surveying 43 years. And I did it because I liked it. It wasn't for the money, but it's just become almost not money.
Members of the board, as I said during the charge, we can take additional testimony. And since two of you asked both witnesses questions, I'm going to take that as a motion. But you all had to open the record for additional testimony. But because we have now heard additional testimony from both Ms. Mulder and Mr. Atchison, I'm going to give Mr. Joseph an opportunity at this time to ask him any questions he has about their recent testimony. Go ahead, Mr. Joseph.
When was the last time so you had to do your license a little bit after you signed this December, correct? That's correct. All right. How much did you cost?
I paid $230 for that, and partially it's anywhere from $250 to $400. It was $15 of PDAs that are required each year. So 1 year you're looking at approximately $400 to justify the requirement, and on the following year you're looking at $1,700.
How much have you spent over the past 2 years, 2011 and 2012, in obtaining continuing education courses for
I'd say $600. That's 32 PDHs.
You still are going to attain this continuing education on your life as long as your license remains active, correct? We'll keep doing this every year.
You have to. I mean, there are people that I know personally, and I worked for one many years ago, who don't survey at all. If you don't pay it, then your license.
Let me ask you this. Since you stated or testified that obtaining the continuing education is very important to any license, must maintain the license. Paying this consent order should be just as important, should it not?
It should be.
And it should have to remain good.
I'm not interested in that, and I don't wish to sound like I can.
But the difficulty I'm having, you talked about all these other things, which is important, like other things that you had to pay. But why wasn't this consent order just as money?
It was, but I put my priorities in the wrong place. I should have just, after March, I'd given up my house, my vehicle, paid the fine, and then tried to pay my license.
Based on what you just stated earlier, that you only had 3 or 4 surveying jobs, you need a registered land surveyor registration any longer?
No. I'm not going to pursue it if I don't have a job at it, but there's always hope that someone will come along and say, we look at your experience and what you've done, and somebody may be willing to work part-time or something doing it. I don't know. I mean, I never thought I'd be working at a medium or minimum wage job during my life. When I was going to school and stuff, I did it. After I got out, basically all I've done since I got out of school, I'm a servant. It takes all my pride to have to go and work a job that people work at Walmart. It's on that level where there's no mental challenge, there's nothing required, just our body fills space for next to no money. I mean, $7.50 an hour is not making this economy. Even living in Perry County, which is a real depressed cheap area, cost of it is cheap. Away from Nashville, but it's the way life is. I accept it. I accept whatever the board decides to. I mean, it's not like I'm going to go out and I'm going to take on a big survey project tomorrow. I've come to the realization that probably my time is surveying.
Thank you, Mr. Anderson. That's all, Your Honor.
Thank you, Mr. Joseph. Do you have any other questions for Ms. Mulder?
No.
All right, members of the board, while we have the record reopened, do you all have any other questions for Ms. Mulder or for Mr. Atchison? All right, we'll turn it back over to you, Mr. Chairman, to continue with deliberations.
We apologize.
Nope, that's quite all right.
That's have a board.
That's quite all right.
You haven't said anything.
No, I haven't said anything. Mr. Atchison, I'm very sympathetic to your financial position. I, too, am a small company, and I understand your plight. I understand the problems of having to work in a one-man or a two-man organization, and the jobs that do or don't come your way and what have you. However, like Tim, I feel like that the consent order that was signed should have had a priority somewhere along the line there. It should have been put into whatever the rest of your payments were and this kind of thing. And I understand $7.50 an hour is not much to spread around in addition to the Social Security that you were drawing, but I think that my decision about this would be that your license should be suspended rather than revoked until such time as you would complete the payment as in the consent order and complete the ethics training. I believe you need to go ahead and do all of that if you intend to sometime at a later date pick up surveying again. That's just my opinion about it. It's just something that you need to do. If you couldn't do that, you probably should have come back to the state and said, hey, look, I am having financial difficulty and here's what's the story. And you should have asked for some kind of guidance along that. You didn't do that.
Okay, haven't heard what you all said. Basically, I think the spirit of the board then is to stay in tune with the judgment that Mr. Joseph has offered. Is that correct? Put words in anybody's mouth. In other words, the judgment that he's handed before us, which would basically suspend Mr. Atchison's license for a 6-month period and indefinitely until he complies with the items that are listed in the proposed judgments, items 2, 3, and 4. Is that what this board would like to recommend to the judge?
Yeah, I think that's very well stated. I don't think that we want to add anything in conditional. I just think that needs to be met as chosen.
Mr. Chairman, so the record's clear. I know you're all looking at a proposed order that I'm going to put into the record as technical record entry number 4. I do need for you all, so that we're all on the same page, to go through, if you would. We still need to have specific findings of fact and conclusions of law in order for the staff to draw up the order.
So, is Your Honor asking me, as I did once before, to read the findings of fact and also the proposed judgment?
Well, I would go through each one individually and make sure you all, as the board, agree that everything that's in the order you're preparing was presented to you during the proof of the case.
Okay, thank you. Okay, on that basis, then, we'll go back to the first page and address the proposed findings of fact. There are 6 findings of fact. The appropriate question would be, has each member read these findings, and do you agree with these findings?
Yes.
Okay, we all agree with the findings of fact. Now, the next phase is conclusions of law, which we have been provided. This is our basis for making our decision for our judgment. There are 4 conclusions of law. Has this board read and understand the conclusions of law that we're utilizing to base our decision on?
Yes, I have.
Okay. Now, having looked at those 2 items, I will now read the proposed judgment as written, and we can acknowledge that we agree with whatever we want to do. Okay, is that correct, Your Honor?
Yeah. Back on your findings of fact, or you've gone. You really haven't identified other than that you've got 6 of them.
Okay. If you'd like to read, I'll read them.
I would either read them or at least discuss them individually to make sure that we're all, again, for our purposes, I want to make sure that the record's clear in case there's an appeal, so whoever reads this on appeal would understand what you all, what your thoughts were, where you all got your decision.
If you'd like, I will read it.
I think that, and then it's for clarity, if after you finish those, somebody will make a motion and I will accept those facts. Or not. Again, you don't have to do 6 individual motions, but I would do one for each section of your order if possible.
Okay. We will revisit findings of fact. Item number 1 under findings of fact states, at all times pertinent hereto, respondent has been a registered land surveyor by the board, having been issued certificate of registration number 1867 on February 26, 1997. Respondent's registration is scheduled to expire on the renewal date of December 31st, 2013. Item number 2. In September 2010, respondent signed and consented to the entry of a consent order approved by this board in case number L10-SUR-BS-2010-000621, wherein he admitted that he committed communication errors regarding his participation in a project involving the survey of a particular parcel of land that contributed to the confusion as to the factual boundaries of the parcel in violation of Tennessee R and Regs 0820-4-.04 public statements. Item number 3. This consent order in case number L10-SUR-RBS 2010-000621 was entered on September 16, 2010, and respondent was assessed a $1,000 civil penalty payable to the state of Tennessee in 13 monthly installments of $75 each and 1 monthly installment of $25, with the first monthly payment being due on September 30, 2010, and with all further payments coming due on the last business day of the month. Respondent was also required pursuant to this September 10, 2010 consent order to take and improve attendance at 8 hours of continuing education courses on the subject of ethics. Item number 4. Respondent did not make the first September 30, 2010 installment in a timely fashion, and thereafter has only submitted through the present a total of $150 towards this $1,000 civil penalty assessment, said amount being received on November 17, 2010. Respondent was scheduled to have completed his monthly installments on his civil penalty obligation on or about November 30, 2011, had he adhered to the terms of the consent order. Number 5. Further, respondent did not submit documentary proof to the board of having completed the 8 hours of continuing education courses on the subject of ethics after entering the order as required. Item number 6. Respondent has violated the provisions of the board order to which he is a party. His actions in this regard can be deemed misconduct by the board. The chair would now entertain a motion to concur with these findings of fact.
So moved.
A motion? Second. We have a second. All those in favor say aye.
Aye.
Opposed likewise? Okay. Now, we continue. Conclusions of law. Item number 1. I don't think I'll read all of this, if that's all right with Your Honor, but I will stipulate the section that we're dealing with, if that's okay, just in the abbreviatory manner. That's all right. Item number 1 deals with 62-18-116, which is denial, suspension, or revocation of certificate based on disciplinary action. Item number 2 deals with 0820-4-.07 misconduct. Item number 3 deals with civil penalties, 0820-1-.06. Item number 4 I will read. Respondent's violations of the September 16, 2010 consent order and his violations of Tennessee Code Annotated 62-18-116 A, 1, B, and C, and of Tennessee Comp R and Regs 0820-4.07 parenthesis 3 also constitute grounds for the board to revoke, suspend, or refuse to renew respondent's certificate of registration pursuant to Tennessee Code Annotated 62-18-116A1. Moreover, the board may assess penalties and investigative and hearing costs on account of such violations pursuant to the above authority in Tennessee Code Annotated 56-1-308A and 56-1-311, Tennessee Comp R and Regs, and 0780-5-11.01 assessment of investigatory and hearing costs. These are the conclusions of law that we are to utilize in the basis of our decision. Do I have a motion that so stipulates that we have utilized these in our decision?
That's what we want.
Do we have a second?
I'll second.
Okay, we have a second. All in favor?
Aye.
Aye.
And are you finding that your findings of fact support violations of those particular laws you've identified?
Yes, ma'am.
Go ahead and find that then.
Okay. Okay. Do we have a motion that stipulates that our findings of fact are based on those conclusions of law? Is that the way you said that, Your Honor?
Well, no. It's close.
Okay, I'm sorry.
Your conclusions of law your order needs to identify that the facts you've already found demonstrate that the respondent has violated your laws.
Okay. Do we have a motion to that effect?
If you go back to at the beginning of each of these paragraphs, the way Mr. Joseph has proposed it,
Yes.
respondent's acts, conduct, as set forth in numbers paragraphs 2 through 6, and the findings of fact constitute misconduct of these rules. You just want to make sure that that's included in your order or something to that effect, if that's your decision.
Okay.
I'm not telling you what your decision is, but I just want to make sure your decision needs to not just recite law, but actually reach that conclusion that he has violated a law.
Okay. So we need a motion that stipulates that the respondent's acts and conduct constitutes misconduct based on the conclusions of law and the finding of facts.
That should do it, I believe.
So do we have that?
So,
Okay, we have a second? Okay, all those in favor?
aye.
Okay, good. Okay, now, we're to the proposed judgment that we've already discussed, but we're going to discuss it again. I shall read this. Wherefore, the state hereby prays that the board order the judge and decree as follows. Number 1, respondent's registration as a registered land surveyor issued by this board, number 1867 in Tennessee, is suspended for a period of 6 months, for a 6-month period, and indefinitely until he complies with the following requirements based on the substantial violations set forth above. Those are the items we've already discussed. Number 2, respondent shall remain indefinitely suspended from the practice of land surveying in this state under the conclusion of this 6-month, after the conclusion of this 6-month period, until he pays in full the $850 balance of the $1,000 civil penalty assessed in the September 2010 consent order, and until he delivers to the board's administrative director documentary evidence that he has successfully completed 8 hours of ethics ordered by the board in said September 2010 consent order. Number 3, further, respondent shall remain indefinitely suspended after this 6-month period until he pays a separate assessed civil penalty of $1,000 due to his violation of the board's September 2010 consent order for a 14-month period between November 30, 2011 and present, and until he pays in full all assessed investigatory and hearing costs ordered in paragraph 4 below. Number 4, respondent is assessed all investigatory and hearing costs incurred in this matter pursuant to Tennessee Code Annotated 56-1-311A and Tennessee Compiler Regs 0780-5-11-.01 assessment of investigatory and hearing costs for which execution may issue if necessary. Execution may also issue if necessary in the order for the state to recover a total of $1,850 in civil penalties assessed against the respondent. Now, having read this judgment,
That's the proposed judgment.
Proposed judgment, thank you, ma'am. Proposed judgment, the chair will entertain a motion to concur with these 4 items as read.
Can we discuss
Yes.
this? Let's talk about this.
Okay, sure.
I think, Tim, what we're looking at is the initial balance he owes $850, and the additional amount that has been added to this is an additional $1,000. I think Mr. Jones has put down here. So we're looking, I don't see anything other than the assessment of investigatory hearing costs, which is that included in this additional $1,000, Mr. Jones?
No, yeah, that would be separate. Those would be the costs of Your Honor, with the Administrative Procedure Division and the cost of the court report.
I see, okay. I think my opinion was initially that just my opinion was that I think he should go ahead and pay what the consent order says. I'm not sure that I necessarily agree with paying additional $1,000. However, I'm not opposed to that because of willful violation of the consent order itself and not meeting things in a timely manner and not completing the education while he is still was completing the continued ed for relicensure, but he didn't go back and pick up his extra 8 hours that we asked him to have done. But I'm open for either way you guys want to go with this thing. But as a minimum, I think you should pay what the consent order is. You should pay $80. And the license should be suspended until such time as that's paid. I think you have the additional to that $1,000 that talk about here.
I agree with him. But I don't want to add $1,000 extra on there. I was talking about $1,000, yeah, I'd finish paying that.
The original?
Yeah, the original. Suspend his license until he gets that done. Now,
And
what-
the 8 hours.
And but what I don't understand is if his renewal comes up December the 31st, and his license are suspended, does he get to renew his license?
You can renew, but still under suspension.
Did you get, okay, that's fine.
He would have to comply with the renewal requirements after he complied with the suspension requirements.
I wonder if it goes over December the 31st, so he can't do anything.
Well, let's assume for our argument purposes that it's this time next year, and he actually takes care of whatever we decide. If that's took care of, okay? Then what that does, that puts him back, as in my mind, and maybe Donna might have to speak to this, but as my mind, that puts him back as a licensee, and at that point in time, he then falls under what he's required to do to continue his license, which would mean that he would have to pay his fee and his continuing education, etc. And it may, I wouldn't say that it would have any other penalty or whatever to it, but he would have to, at that point in time, he'd have to fall in line with everybody else. That's the way that I would prefer the indefinite suspension. Well, he's sort of suspended. I mean, he's just sort of there, and then when he complies, then he's back as a regular registrant once all this is complied and approved and so forth. And then he has to now comply to whatever he's supposed to be doing.
With what the current.
Right, with what the current. So, I guess from our discussion, what I'm hearing is, so you and Galen are interested in removing paragraph 3 from the proposed judgment as I read it.
Yeah, I think that would be fair from the standpoint as we look at it and not take his license away, but not require any additional monetary burden be placed upon him.
Well, let me say this. He will have additional monetary burden from the investigatory, I just can't say that word, and hearing costs. That's just not good East Tennessee, I don't know what it is, but anyway, the cost of these proceedings.
Yes, I
he will
understand.
have additional expense there.
Yes.
And obviously there's expense to the ethics, and obviously there's expense to what he owes. The justification in my mind for paragraph 3 is the fact that he has willfully and has acknowledged that he violated the order.
Yes.
And that is the justification for that penalty. Under our civil penalty section, I guess I'm putting my attorney hat on for whatever that's worth. We could have penalized him anywhere from $100 to $1,000 per day. Per day. So that penalty in itself could have been, I'm just going to say, very large, to almost astronomical in a way. And that certainly would not have been fair in any way whatsoever. But we could have done that. We certainly could have done that. So I feel, my opinion is that I feel that paragraph 3 is justified because of the failure to comply. I realize it adds additional financial burden, but you know, as Mr. Joseph investigated in testimony, the respondent stipulated that, you know, that he paid his license fee after this judgment, and he got continued education after this judgment. You know, obviously, you know, trying to continue with his profession, but you know, clearly he's not going to continue with his profession if he's suspended. If he does, he'll be back before us, and it'll be another issue. You know, and I think he understands that. So, you know, my notion is that that the proposed judgment as set forward is okay with me because of that justification. Because, in other words, I don't want to ignore the fact, and I don't think this board is, but I don't want to ignore the fact that we've had a respondent fail to comply, and we have failed to punish via an additional civil. That's just my thoughts on it. And in my mind, it's somewhat of a minimal civil.
Do we have an idea what the costs are for investigating and perhaps the court proceeding here and all this adds to the additional amount?
Mr. Joseph, do you have an estimate of the investigatory cost?
Yeah, Your Honor, we don't have any real investigatory costs. Your Honor's costs, your APD costs would be the major component. The court reporter's costs, at least at this juncture, for half a day, would be probably less than $50.
For the court reporter?
Court reporter, as long as no transcripts are being ordered.
Our costs in this case are probably between, the minimum is $200, and I would imagine they're not more than $350 from our office. Court reporter's about $100.
I know the last case,
$125.
the last one.
But again, the cost, I want to make sure you all understand, the costs are not a civil penalty. The costs are a separate matter.
I
So
understand
I can understand that you want to know what they are as you're trying to determine the amount of a civil penalty. But again, your civil penalty needs to be a specific amount, and you need to tie it to whatever violation you're assessing it for. The cost should be a separate category.
Like I said, the last one.
Well, I still feel like I want to stick with what I have.
Okay. We have a motion.
Ms. Braley, I'm going to ask you to speak up, please. Thank
I
you.
do too.
Okay. You want to make a motion to this, okay?
I so move that we just strike paragraph 3 and keep the civil penalty as I have previously stated, and pay all the previous consent order requirements,
Okay.
and complete all of them.
Okay, we have a second. Okay. No further discussion. Call for the question. Those in favor, say aye. Opposed? Aye. Okay, motion carries. So I thank Your Honor. I think we've come to a conclusion for our
Do y'all
proposed
want
judgment.
to have a vote on your, I know basically you've gotten a vote on paragraph 2, which
Okay.
is to
No, we
have,
eliminated, we voted on eliminating paragraph.
you
3.
eliminated 3,
Yes,
but
ma'am.
what he said was
Okay.
you were going to keep paragraph 2, which was the 850 previous.
So,
But do you want to vote on,
Yes.
or have a motion?
Yes, ma'am.
On what your amount of the suspension is?
yes, ma'am. Would you like to make a motion, and I don't want to put words in your mouth, but for paragraph 1, 2, and 4?
Okay, then I so move that
As written.
we retain the proposed judgment, paragraphs 1, 2, and 4 as our conclusion and decision on this case.
Well, let me, we need a second before we can discuss it. Okay, now we have a second, now we can have discussion. And go ahead, say, I know what you want to say. Yes, ma'am, it does. Yes,
I'm
ma'am,
sorry,
it does.
Mr. President.
Number 4 needs to be revised because it says a total of
Okay.
$1,850.
Okay, I would like to make because we have that motion for discussion, I would like to ask you who made the motion to to allow item number 4 to be amended from $1,850 to $850.
All right. I so move.
Okay.
I'll make that change.
And since you seconded, will you agree with that amendment?
Yes.
Okay, now, the motion, I'll restate the motion if I may. The motion on the floor is to propose a judgment being paragraph 1, paragraph 2, and paragraph 4 to be amended to stipulate that says for the state to recover a total of $850 in civil penalties against the respondent. That is the motion that we now have, on the floor.
That's correct.
Okay. If there's no further discussion, I'll call for the question. All in favor?
Aye.
Opposed? No. Okay. We have a 2-to-1 vote. So, Your Honor, that is our proposed judgment.
Well, no, it's now your judgment.
Oh, it's our judgment. You know where to go from here, man.
All right, and now the last thing you all need is a policy reason to support your decision.
That's the part I really don't understand real well because we based it on conclusions, a finding of facts and conclusions of law, and I don't really, that's the part I don't know. You have to give us a little more.
All right, well, I'll go back to my charge on that. A policy reason must accompany your determination, and that's required by the Uniform Administrative Procedures Act. It is to state the reason why your decision you render in this situation is appropriate. Your policy reason is your statement explaining why the particular disciplinary action you chose in this case is correct, given the wide range of cases you hear and the various disciplinary options you have. Your policy reason tells the public and reviewing courts why the disciplinary action you choose in this case is proper, even though it may be a little different from what you have done in past cases or what you may do in future cases. The gravity of the violation and the respondent's attitude toward the action may be included in your policy statement to support your disciplinary action. This does not have to be a long statement. However, it should not just be a reiteration of the facts you have found in the case or an adoption of your statutory authority to hear the case. Rather, it is simply a short statement as to why the disciplinary action you have chosen here is correct. Does that help you?
Yes, ma'am.
Oh, good.
You want to make it, Gail?
Let me think how I need to word this. I think our conclusion and the reason and the policy behind this is the fact that our respondent, however, violating the regulations under which we all practice and willfully not completing the items in the consent order, I think by the fact that his financial inability to meet all of the obligations here have drawn us to the conclusion that he still needs to comply with the order that was given, the consent order that was given in order to remain in good stead with this board. And based on the conclusions of law that we've seen, we have the right to make any other changes as far as either assessing more or reducing the amount. And I don't see that, based on what we have done here, doing either would be of any benefit one way or the other to this board or to the respondent, other than the fact that it does not add to him an additional financial responsibility burden.
Well, in addition to that, I think that it's imperative that with the charge of this board that the registrants and the public understand that the board does not lightly take rejection of orders that we put forth from either a registrant or non-registrant, whatever the situation may be. We do not take it lightly, and that's probably the most paramount point that I feel like we need to make. Yet,
I do agree.
within the purview of our discretion, it is certainly important that we are appraised of the respondents' situations and scenarios, so that this board may make proper judgments on a case-by-case issue.
So that's a lot of discussion for your policy reason. Does someone want to sum it up so Mr. Joseph will know what to put in the order in that section? Good discussion, by the way.
I'm not sure how I need to sum that up. Put that together. How much time do we have?
All the time you want to take. I have all day.
Well, I think it's the policy of the board to be fair in its judgment and to be fair in what we assess, be it punitive damages and what have you. And I think that the policy is not to impose something greater than one could allow as far as the punitive damages are concerned and the side of the thing. However, it is the responsibility of this board, as was stated, that we have the responsibility to the public and to the profession to make sure that our rules and regulations are complied with. And I think by doing so, we need to assess the respondent with the balance of what was in the consent order that he agreed to pay to begin with. And beyond that, I think that we've been fair in what we have done as far as our policy is concerned, and our charge to protect the public as well as the surveying profession.
You want a motion on the policy statement as stated by Mr. Northcutt?
I make the motion that we accept it.
I'll second it. Okay, I'll call for the question. All those in favor? Aye.
All right. Thank you, members of the board. Mr. Joseph, Mr. Atchison, thank you. We will stand adjourned. Mr. Joseph, if you'll draw up the order, present that to the board chair. Once that's filed with the Administrative Procedures Division, it will become an effective final order. Mr. Atchison, if you would like to appeal the decision of the board, appeals from these decisions go to Chancery Court in Davidson County, and there's a 60-day time period in which
Your
one can
Honor, I
file
wouldn't
appeal.
insult this court or the board.
Well, again, it's your legal right to have that option, so it would not be an insult to us should you choose to follow that.
Can I ask one question?
Yes, sir.
Clear. I understand the remainder of the fine to be paid. I understand the PDHs to be completed. On those PDHs, can I use something with the correspondence course in that particular case where I don't have to go to a seminar, because ethics seminars require me to be trained?
As long as it complies with the board's rules.
Well, I understand it, but see, in the rules and the PDHs, you used to be able to get them all through the classic where you get material online, you go through, you submit a test, and then it's graded and it's sent back to you. And then the board subsequently said that only 50% can be fulfilled in that manner, and the rest has to be live seminars. Well, I can't tell you when the last time I remember there being a seminar on ethics. The last one I think I attended for, the second to last one, we helped TAP's organization in Jackson. Tennessee put it on ourselves over a period of 3 or 4 meetings. That will satisfy the requirement if I go ahead and use, there's a gentleman out of Texas who you go online, get a test, you submit it to them, and they return a certificate.
As long as it complies with the board's rules.
And it is
The
in
board will
addition
review
to,
it when you submit it.
I understand, and it's in addition to the 16 hours that will be required to submit into 2013.
Yes, that's correct. separate issue.
I understand. Okay, now the court costs, as I understand them, are $350 for the judge and $150 for the...
That's an estimate. What Mr. Joseph will do is he will get the bill from the court reporter. He will contact the administrative staff in my office, and they will do a certified amount of what our costs are. Again, without looking in our computer system, I can't tell you my estimate. It's probably no more than $350. It's probably less, actually.
Okay, now that is a separate matter from the $850. So the $850 is payable to the state board, and the costs are payable to the state
The costs still come to the state board.
It would all come to us, and it would be set out with specificity in the final order. That is,
The amount.
Set forth the judge's cost, the court reporter's cost, total cost, and then the $850 in civil penalty. But all payments would come to this department.
When you send me a copy of this...
Yeah, when you get the final order, at that last paragraph will have both the $850 and the total for the cost.
And after a period of 6 months, if I've completed all these requirements, then my license will be reinstated.
That's what the order says. Yes, sir.
And then I will have to, okay, now I have to go ahead and spend money to review it. I thank you for your consideration. Thank you for your time.
Thank you, Mr. Ashton. Thank you,
May
Mr.
I
Joseph.
leave?
Yeah. Yes, we are now.
I got about a 2-hour drive, and I like to get home.
Yeah,
fast.
we are now adjourned. Thank you all.
Okay, thank you.
I need your thoughts on it. Don, if you'll turn the TV off, we'll take a break. Okay, it's now 12 minutes after 11. We have concluded our formal hearing, and we will now come back to our normal business. And in doing so, we will appropriately call the meeting to order. And the first item on the agenda is to adopt the agenda. Hopefully everyone's looked at the agenda. Does anyone have any additions or changes? I would like to make a couple of additions, if I might. In your package that you were sent to you through email, you were added at least one other individual, Tommy Young, under continuing education. And I understand that we have another individual, Marion Young, that also has another continuing education question. I'd like to add those two to the agenda under new business. And also one other item under new business. I think it would be appropriate if we spend a little bit of time either today or tomorrow discussing what we want to discuss at the TAPS roundtable. So if no one has any objection, I'd like to add those.
No objection.
Okay, so we need a motion to add those to the agenda.
Also moved.
We have a second. Those in favor? Okay. Now, since those have been added, I'll accept a motion to adopt the agenda as amended.
So moved.
And those all in favor?
Aye.
Okay. Now, our next item is annually we adopt Robert's Rules of Order for the functioning of this board. So we need to have a motion that so stipulates that.
Mr. Chairman, I make a motion that we use the Robert's Rules of Order for the conducting of business with this board.
Okay, those in favor say aye.
Aye.
Okay. All right, the next item on the agenda is review of the previous Does anyone have any additions, deletions, corrections to those minutes? If no one does, the chair will entertain a motion to approve them as written.
Make a motion that we approve the minutes as written.
Second.
Okay, we have a motion and a second. Call for the question. All in favor?
Aye.
Okay. Okay, now we come to the legal report, and I'll turn that over to Mr. Herndon.
Okay. Page 10. Set at the bottom.
past page 6, one more page, two pages past page 6 at the bottom.
I saw 7. They're on one.
Go past page 7 and you'll be at it. The next
I know where it's at. I just didn't know page number there.
Oh, well, all right.
That'll be an obstacle. It's normal.
Thank you.
Right, sir. Thank you.
Now when everybody's there.
And Donna, can I get a paper copy of the, also?
Don't let me forget it.
Thank you.
All right, we got 3 categories. We've got cases that went to litigation and came back for your further consideration. Another one where cases went to a reviewer and new cases. So the first one, there's only one. First heading, case referred for litigation activity. 3 of them were referred to litigation from last time, and you just heard one.
Okay.
Another one remains there, and then this is the third. So this is case number L12 SUR RBS 2012-010551. This matter was presented at the October meeting as companion, which this is Respondent 2, to a case that was settled through a consent order as follows. The complaint alleges unlicensed conduct on the part of Respondent 1, unlicensed, located in Alabama by using Respondent 2, which is this person, licensed, located in Florida, seal on caps, and alleges misconduct on the part of Respondent 2 for taking part in this venture. The investigation was ordered and a report received by this office detailing the arrangement. The investigation reveals that the two are not employed with each other, and that Respondent 2 is never located in Respondent 1's offices, and that all reviews were conducted at a distance. Although the investigation has the unlicensed respondent stating that approximately 6 land surveys in the state of Tennessee over the last 24 months were prepared under the licensed respondent seal, the file does not contain any documentation bearing that respondent seal. At that time, the recommendations were, for the first person, licensed respondent, consent order for a civil penalty of $1,000 for unlicensed conduct in violation of the appropriate statute. Noted this settlement offer was accepted and the matter closed as it related to Respondent 1. For the licensed respondent, who is this person, the consent order in the amount of $2,000, $1,000 for violating the rule for misconduct for furnishing limited services in such a manner as to enable unregistered persons to evade federal, state, and local surveying and planning laws and regulations or our laws. Additional $1,000 for violating Tennessee compiled rules and regs 0820-0409, responsible charge of service for not being employed or present at the office providing land surveying services. The board's analysis, after having been told all that, is to approve the recommendations with the additional requirement that Respondent 2 should be required to take 8 hours of ethics courses in addition to the recommended discipline. Here's the update. Respondent 2 has reacted to the settlement offer by informing the board that his financial situation will not support the settlement offer and has returned his wall certificate with a request that the board accept his voluntary surrender of his license. The reason that's back with you is because you didn't authorize me to accept anything like that. So my recommendation in the face of that is to rescind the consent order and issue a new consent order accepting the surrender as if revoked, and that the respondent will have to reapply to obtain a valid license in Tennessee. So instead of $2,000 and 8 hours of ethics, he responded by sending his wall certificate in saying, I'm not going to play anymore. My recommendation is that we rescind the previous one, accept the surrender as if revoked, and you have to reapply.
Is it necessary that you stipulate that the respondent has to reapply?
If he's revoked, you have to reapply.
I understand it, but is it necessary that you stipulate?
No.
I have no problem with the consent order. Volunteer won't surrender their license. I have no problem with that. I just, I think that I don't think that we're obligated to tell him that he has to apply for his license. that we kind of understood. And I think that the board certainly would, look at the situation.
It doesn't matter to me one way or another with that, but
It would be the license.
just in case you don't know this is what you want to have to do. You need to come back and practice this.
And even if somebody reapplies, it doesn't guarantee that you'll get a license.
No, and especially a short-term turnaround, revoke, and 2 years from now he decides to come back, and, he just did this to avoid.
I wasn't willing to bring back a voluntary surrender, because that's not a discipline. That's just, I don't want it anymore. So that's why I recommended surrender as if revoked. I've seen that language in other states.
Well, that's a good point, Rob, because if we issue that consent order in that manner, then it would be Donna's obligation to notify the state of Florida or any other state that if he has surrendered his license as is revoked, and he may face other disciplinary actions in any other state. We know his license in Florida, but just by the complaint.
That's
Any
true.
other state that he's licensed in.
That would be up to that state board,
Right.
but they would know about it through NCAA's.
Well, I recommend we take your recommendation.
Do we have a second for that? Okay, we have a motion and a second. All in favor?
Aye.
Okay. Go to it, Mr. Herman.
All right, next heading is these some cases that are under analysis, and this will take a little bit of time. Case number 1 is 2012-01-0861. The complaint alleges the respondent, a licensed land surveyor, displayed incompetence and/or committed misconduct in the practice of land surveying. Specifically, the respondent may have caused or significantly contributed to a land dispute in connection with his preparation of the plat. In possible violation of 62-18-116, which forbids you being incompetent, and Rule 08-2003, that whole chapter standards of practice. There's no previous complaint history for this respondent. The case materials were forwarded to a complaint reviewer for analysis to identify probable cause for discipline, if any. In general, the reviewer finds cause to believe that TCA 62-18-116 has been violated. This statute states that a land surveyor may be disciplined by this board for any failure to comply with the minimum acceptable standards of practice properly established by rule. And following are the results of his analysis of the respondent's work product. I'll take it one at a time here. The first one is Rule 08-2003.07, subparagraph 1B7, which recites, the land surveyor shall comply with the minimum requirements provided below for all surveys and survey plats or survey maps prepared therefrom. General property surveys. A survey map or survey plat shall have a title and contain the following information. The certification on the face of the final survey map or survey plat as to the category of the survey and the ratio or precision of the unadjusted survey, which shall have the following minimum content. Certification as to category 1, 2, 3, or 4. Ratio precision of the unadjusted survey, statement that the survey was done in compliance with current Tennessee minimum standards of practice, signature and registration number. Now that's the rule. And here's the analysis. The case reviewer states that the certification on the face of the survey shows that the precision ratio of the unadjusted survey is exactly 1 to 10,000. The reviewer has concerns that a land surveyor conducting a boundary survey matches an unadjusted closure of exactly 1 in 10,000. The respondent's prepared survey matches land descriptions in Deed Book 706C, page 53, exactly for bearings and one distance. In light of this, the reviewer requested and was provided the respondent's field data in order to determine how this ratio was obtained. Upon review, the data provided by the respondent seemed to be insufficient for this purpose. It was submitted in an ASCII format and only contain point numbers, northing, easting, elevations, and descriptions. Tie numbers 30 to 33 provided are assumed by the reviewer to be traverse points for closure. The sketch shows tie point number 34, however that point is not included in the ASCII file. Without raw field data, which apparently doesn't exist due to the failure to provide it requested, the closure can't be determined. The second rule, 08-20-0307, paragraph 1H3, is quoted as follows. The land surveyor shall comply with the minimum requirements provided below for all surveys and survey plats or survey maps prepared therefrom, general property surveys. Monumentation requirements. The type of monument, old or new, should be indicated on the survey map or plat along with the size and type of material. No monument should be placed if, in the opinion of the surveyor, the existing monument, whether original or not, is found undisturbed and adequate to perpetuate the position, can be reasonably made to conform to the angle point in the boundary. Large or indefinite monuments which cannot be measured to within the positional accuracy requirements contained herein, such as trees, rock piles, or fence corners, will be marked with witness monuments as deemed necessary by the surveyor. The next paragraph is in comparison to this rule. The case reviewer states that the survey does not show the type of monuments located. 2 points are shown only as fence intersection. After acquisition of the requested additional data, the reviewer says that the indication is that points 110 CP and 113 CP are fence intersections. However, no field located points match the CP points. Points 110 and 113 are assumed by the reviewer to be calculated points per deed calls. And the last rule is seals, 08-2004.08. The registrant shall superimpose his signature, not a rubber stamp, and date of signature across the face and beyond the circumference of the seal and documents to which his seal is affixed. The case reviewer states the respondent did not, on the sealed survey provided, show the date of signature across the face of the seal. Alright, having compared those three rules, the recommendation is to issue a consent order based on this probable cause for a civil penalty of $500 for each of the rules allegedly violated, for a total civil penalty of $1,500, with the additional requirement to prove to the board that the respondent has completed a number of hours determined by the board, continuing education on the subject of standards of practice. I've read all that in the record. Take your time and digest all that.
What did he do wrong? Let's turn this. You put a sale, his name across the sale.
Well, that's sort of obvious. I can tell you what I think's wrong with it. You're supposed to keep your field data. You're supposed to keep that. You're required to. We asked you. He said, what I explained, he said, that's not what we asked for. We asked for field data. I asked for it by letter. It wasn't provided, so we can only assume that he doesn't have it, which in itself is a violation. The reason it was asked for is because how could it possibly be exactly 1 to 10,000? Unless the line is that long.
That's the first part of this.
I think your recommendation probably probably not stepping up, but by the same token, that's probably won't get the respondent's attention.
I have a question after we discuss this once that was brought to my attention.
I don't know how we come up with that. classic way, we probably should.
Absolutely. I agree. Kentucky has it, we should have it. Standard of practice and ethics. Oh my goodness. The majority of these things as they come in tell us that we
They cry for it. They cry for it.
Well, the good thing about having reviewers now is that now people that are practitioners every day are looking at other people's stuff. I'm not saying they're wrong or anything, but people sort of get comfortable after a while. And that kind of needs to stop. Because this is an example. Nobody's perfect, I understand that. 1 in 10,000. Can't improve it.
Yep.
The largest issue I have is a implementation issue.
He didn't monument it.
On monument, nothing. I mean,
Regs say
and it
monument.
appears that he's copied an OD per se. He's found enough and said, looks close enough to LD, and I can fix one distance here, and it closes to it. I mean, that's what it says to me. The fact that he put the date across the seal, I don't have
One of your
a, he's
concerns.
supposed to, but,
I know another fellow that didn't do that one time. So.
that's not the end of the world on that one there. I have an issue that it just kind of, well, y'all said I had to put that on the plat, so I put it on there.
Yeah, that's
Now you're telling me I'm supposed to put some other number on there.
Just putting it on there.
And that's what that says to me. I mean,
What you're saying is probably a reflection of the prevailing attitude.
yeah. No disrespect to person or anyone else. I mean, this cries to me as possibly an older surveyor, and it's the way he's been doing it. And now here it is.
There's no reason to think the person in general doesn't know what he's doing.
Right.
But record keeping has fallen out of compliance, apparently. And I'm not a surveyor, but it seems like it would take a little bit more heavy lifting to actually calculate your error ratio than just to put something on there, that you're required to.
Well, it all goes back to how you did what you did.
That's what we wanted to see.
Yeah, if you did it open-ended or closed traverse or, whatever it is.
Yeah. He forced the traverse closed or
Right.
How it was done.
Follow the receipt.
I'm dealing with subdivision. I can put the actual motion in. I know that there are companies that I don't mind. But if he says it's exactly that, I do think he's right.
One of the important things about this is these people that see it, and they're swearing and doing that. You need to really be aware when you do that. There's people lying these documents.
This person is not perfect.
That's what we're trying to do.
That's right. I agree. I had a request.
Right.
I had a request last week by a farm husband. And he said, if it comes out on a tree, just use that tree. I said, I can't do that. And he said, well, why not? And I said, because regulations say that I have to monitor that corner. I can do it to a 10 by 36 inch wire. So I can My closure gets to be somewhere within this area.
I think you can,
Well, if you witness monument.
That's what the rule says. So if you got some rock pile or something like that, or a tree, I mean, the rule tells you to do that.
Well, most surveyors are like Galen when it comes to new surveys, cutout survey, new survey. They want to be able to set iron pin caps on them.
That's what I do.
That way, it's best if you do, but sometimes you just can't convince Farmer Joe that that's the way you want to cut it.
Well, as long as you document it, you're better off if you have something in your work notes that says, I did it because of this, just in case it comes up.
Well, it's the recreation. Can the next guy recreate what you did without significant, that's
Well, with your recommendation, I think that's probably a good recommendation, and I make a motion to accept the recommendation.
well, before you have the motion, let's discuss what we want to do with the recommendation on standards of practice.
Gotcha.
That's the only thing I think we need to touch. I don't disagree with what you're saying.
Yeah, okay. You want to call him in here and send him to the board, and let's go over standards of practice with him?
No, I don't really.
I don't either.
But I don't know how we approach that, because to my knowledge, I don't know of a current active course in Tennessee that's specifically standards of practice oriented.
Yeah.
That's the only problem. We're trying to get to that point in what we're doing, but we're not there. For the sake of argument, somebody that's not offended before, $1,500 hit's going to be pretty good. Certainly more than he got out of the survey.
Yeah, it erases whatever property.
And I think we're going to get his attention.
We can take out the taking the classes if they don't exist anyway.
You okay with this, Susan?
We can just,
Chair will entertain a motion.
All right, I'll make a motion then that we accept the recommendation minus the requirement for review of standards of practice.
so just the penalty only.
Second. Okay, we have a motion second. All in favor?
All right.
Okay. All right, we'll go to the next one.
Real estate appraisers never have problems like this. All right, number 2, 2012-017811. The complaint alleges the respondent, a licensed surveyor, committed misconduct in the practice of surveying. Specifically, the respondent either failed to comply with the board's minimum standards of practice or failed to complete a plat, a possible violation of 6218-116 and Rule 08, the whole chapter, Standards of Practice 082003. There's no previous complaint history for this person. A review of the complaint materials identified the allegations as involving incompetence in starting work on a plat and never completing it. An investigation was ordered to collect details on the events and surrounding the complaint. It was found that the matter involved an estate probate among 7 descendants, one of whom is the originator of the complaint. The first issue involves a description in either 2006 or 7 of a lot for a house inside the complainant's sibling's farm tract made for the sibling's daughter. This lot does not front on a public roadway and is accessed by a private right-of-way. The access requirement to front on a public road is not a survey issue, but is rather one involving planning codes that is not enforced locally. The second issue is that the respondent never completed a plat that he started. Court probate activity indicates that the survey was actually never started, as it was unnecessary because a previous survey existed, and the respondent agreed with its conclusions. Complaint information does not reveal that there was ever a contract to produce it. Once probate began in earnest, the respondent reviewed whatever matters requiring surveying to another land surveyor, preferred whatever matters requiring surveying to another land surveyor due to the respondent's lengthy past involvement with members of the family who perceived the conflict, particularly the deceased owner whose property is at issue, perceived conflicts of interest at worst and charges of bias at best. To be thorough, the matter was referred to a complaint reviewer for any indication of misconduct on the part of the respondent, and the opinion returned was that the entire matter is an issue for the courts. There is no evidence in the materials that the respondent did anything improper or violation of the board's laws and rules. Based on that, the recommendation is to close the case for lack of probable cause for discipline. Close, not dismiss, just in case someday we hear something. Makes us want to reopen the case.
Any discussion? Hearing none, do we have a motion?
Second that.
You can dismiss if you want. I just recommend it.
Close.
Okay. Close, okay, you close?
Yeah, closes.
All right, we have a motion to close per Robert's recommendation. Any further, we have a second, do we have any further discussion? If not, all in favor? Hey, Rob.
Number 3 and number 4 are sort of companion cases, so keep that in your head. Number 3 is 2012-020071. And there's a note at the top. This complaint involves a boundary dispute with the complainant owner of the same property as the following complaint, which is number 4, 2012-025681. This complaint alleges the respondent and licensed surveyor displayed incompetence or committed misconduct. Specifically, the respondent may have caused or significantly contributed to a land boundary dispute in connection with his preparation of a plat, possible violation of 62-18-116, and Chapter 08-2003, which is our standards of practice. The plat prepared adjoins the complainant's property. There's no previous complaint history for the respondent, so the complainant is next door. The complaint includes evidence of an adversarial relationship with the adjoining landowner who employed the respondent, including the swearing out of restraining orders. The complainant claims the respondent did not consult the previous survey done on the complainant's property while determining the common boundary, along with claims that there are errors and omissions and date changes on the respondent's plat that contributed to the boundary dispute. This matter is currently in litigation. Materials are forwarded to a complaint reviewer to determine if there is any probable cause for discipline due to any misconduct or incompetence. Cited the whole rule, but it's just one thing. Otherwise, the reviewer decides that there are any other violations. Since we efforts to keep the respondent from a lot of problems.
Yeah, I got a survey of my property, and that survey
look at it, or he didn't take it under advisement.
He had it, he doesn't necessarily have to follow it, but it's fast.
Worthless, right? Out of the correct can come. However,
That looks like what's going to happen, looking at the investigation report.
that the surveyor did have it, but he didn't consult it or chose not to follow it.
Well, that's fine.
And I don't have a problem with that.
Yeah.
So everybody is graphically aware that there is a plat.
Okay.
They just, as a matter of fact, that's
Well, I mean, what we read didn't infer
Yeah.
that.
That's right, it did.
the reviewer didn't particularly go there because I guess after reading the materials, it
Okay.
came to that conclusion. That Mr.
Well, that's the only reason why I brought that particular statute, that
Okay.
section up, is because what that implied that the respondent just ignored it.
Okay, well, that's my mistake. I didn't mean to
Okay.
give that impression.
Okay.
But certainly, we want you on the record to come to the correct conclusion, so I'm glad that that came up.
He may have ignored the survey once he had it,
Well,
but
the person that created the survey was available to be talked to and discussed with in both these cases. So I didn't put that in here. But
I just think any surveyor that does take advantage of talking to the adjoining party surveyor or take a look at his plan, and at least give some consideration as to what was done. That I think he's nuts.
the disagreement to the conclusions of these two surveyors is sort of what generated the whole.
And apparently that's it would. Are these two tied together then? These two complaints?
They're on different. They adjoin
But they're different
a
issues.
bunch.
Yeah. Okay.
Well,
But the two complaints contain different issues, correct?
actually, not exactly. The complainant is the same in both cases, and the allegations are about the same. They're just two different respondents on two different parcels of land that adjoin the same complainant.
Oh, okay, so the complaint is kind of the guy in the middle, and the first complaint is on the guy that surveyed to the left, the second complaint is on the guy that surveyed to the right.
Okay.
Okay, okay.
And you're going to hear almost identical.
So what it amounts to is the complainant is saying, hey, look, my survey's right, and you two guys that surveyed beside me are wrong. Okay. Okay, I got the picture now. I'm a little slow, but I figured
That's
it
all
out.
right.
Well, I didn't want to present it like a soap opera.
Well, no, that's fine. We just want to get our arms wrapped around it. So I guess we're ready for a motion for this item.
My motion would go with Ron's recommendation. Close it with a letter of caution.
Sue?
I second.
Okay, we have a motion second. Any further discussion? I'll call for question.
Aye.
Okay. Sue, you and I? Okay, all right. Continue, Mr. Hurd.
Behind it.
Number 4, 2012-025681. And there's a note that's very similar on the top. This complaint involves a boundary dispute with the complainant owner of the same property as the previous complaint, 2012-020071. And just for the record, this complaint alleges the respondent, another licensed surveyor, displayed incompetence or misconduct in the practice of land surveying. Specifically, the respondent may have caused or contributed to a boundary dispute in connection with its preparation of a plat, possible violation 6218-116, Chapter 08-2003. The plat prepared adjoins the complainant's property, and there's no previous complaint history for this respondent. All right, this complaint includes evidence of an adversarial relationship with the adjoining landowner who employed the respondent, including the swearing out of restraining orders. The complainant claims the respondent did not consult the previous survey done on the complainant's property while determining the common boundary, along with claims that there are errors and omissions, date changes on the respondent's plat that contributed to the boundary dispute, and the matter is currently in civil litigation. The materials were forwarded to a complaint reviewer to determine if there was any probable cause for discipline due to misconduct or incompetence. In this particular case, the reviewer did not identify any noticeable violations of any of the board's minimum standards of practice after a careful review of the respondent's prepared plat and other work products. So, slightly different. He didn't find anything wrong with this one. So the recommendation is to close this case for lack of probable cause for discipline.
But by closing both of these cases, we leave the door open if this litigation happens to
And that, yeah,
take us in another direction.
whenever there's something like this going on, I always recommend you close because you never know.
I agree with the recommendation. I'll make a motion to accept the recommendation.
Okay, we have a motion second. All in favor?
Aye.
Okay.
All right, steaming along, number 5.
We got 2 more cases. Y'all want to go ahead and get those for us to break for lunch? No kind of get proper concluded. Okay.
Just a little
Mr.
extra.
Cole, won't be too long.
I'll be fine.
before 2 o'clock, I'll be fine.
Okay.
After 2, I get a little cranky.
You know what you gotta have.
Number 5 is 2012-021751. And this complaint alleges that the respondent, the surveyor, committed misconduct in the practice of surveying. Specifically, the respondent is alleged to have created an incorrect boundary survey in which a new fence was constructed encroaching on property owned by a homeowners association buffer easement. The complainant was charged a large fee to relocate the fence due to its placement based on the incorrect boundary survey that the respondent prepared in possible violation of 6218-116 and our standards of practice. The material was first sent to investigations to gather details on the events leading to the complaint, and then to a complaint reviewer to determine if there were any violations of the standards of practice and law. The reviewer identified at least one specific rule which seems to have been violated. And that rule is Tennessee Compiled Rules and Regs 08200302, Standards of Practice, General, which quotes, the proper execution of land surveying and mapping procedures and all other details of a land survey shall be the direct responsibility of the land surveyor whose stamp or seal and or signature appear on the map, plat, or other newly original survey documents. And Tennessee Compiled Rules and Regs 08200402, proper conduct of practice. The registrant shall at all times recognize the primary obligation to protect safety, health, and welfare of the public in the performance of the registrant's professional duties. All right. The reviewer reasons that these rules are potentially violated due to the fact that the land surveyor must follow standards of practice even without the issuance of the survey plat. When conducting a survey for any construction, stakes must be marked clearly indicating the area for the appropriate construction. The recorded plat obtained by the respondent clearly indicates the location of a 25-foot landscape pedestrian access public utility and entry easement. The respondent stated that he left a copy of the recorded subdivision plat on a second trip, so he must have had it in his possession upon producing the boundary survey. Additionally, the respondent has a professional responsibility to inform the client or any involved party of any recorded easements that may affect any intended construction. Additionally, there seems to be indications of either misconduct or incompetency in the fact that the respondent has given contradictory information in that the respondent first states in writing that he was requested by the complainant to find and or reset the boundary property corners for the lot. In the interview with the investigator, he then says that if he, the complainant, had asked me to stake for building his fence at the proper location, I would have done so on the first trip. Finally, in the respondent's letter to the complainant, the respondent stated that as I was looking back at my call logs request from the complainant's spouse in December, I have recorded that he was requesting me to locate and stake the lot so his builder could build a fence. At the least, there are indications of either faulty recollections of events or faulty record keeping, either of which can negatively impact client relations. I had a little trouble with this recommendation, but I've decided to recommend a consent order for a civil penalty of $500.
Statement in there, Rob, concerns me. It says, when conducting a survey for any construction, statement must be marked clearly indicating the area for the appropriate construction. I have no idea where that statement is in any of our stuff.
I don't think that's recited in the rule. I think that's the opinion of
The reviewer.
professional opinion of the reviewer based on his interpretation of this rule. don't think you're going to find that. But once again, he's offering his opinion. You certainly don't have to follow it. Because the whole basis for discipline was, as you can see, neither one of these rules is technical. It's just saying that you need to do everything you can to make sure it don't cause a conflict. And that's why it's later recited that there seems to be some kind of communication mix-up, but it just sort of degenerated from there.
Did I understand correctly on this that the surveyor, even though he had the plat, didn't take the plat with him when he staked the lot, or what am I seeing here?
Well, he says he didn't have the plat, but then there's indications from things that he said that he must have had the plat and didn't follow it. That's what it looks like. This person, this is a subdivision.
Yeah.
This is a little background on it. This is the same surveyor that laid out a lot of the plots for these people's houses. One of these previous people asked this person to come back and do this service. Apparently it wasn't done very carefully. All I can think of, he ended up putting the fence in the middle of these. They had to move the fence. Which to me seemed a little bit careless. If, like you said, if you have access to everything you need, just to run in and shoot a line, and it's in the wrong place.
You know, and I'm not sure what the surveyor really was asking to do, if he was asked to stake the subdivision lot.
We don't either.
You know, so if the complainant asked the surveyor to stake the lot, if he had asked me to stake the lot, I take the plat, and I take the plat with me, and I go out and I do my reconnaissance, and I find monumentation sufficient enough to know whether it's reliable or not, and then I use that if I have to set anything, and I usually just set and mark corners. Then if that client says, all right, I need something on the sideline here because, and I said, well, you've got an easement right here, and if the easement states you can't construct anything in there or over it or what have you, generally on easements, you know, you can construct on either end of the thing, whatever, around the thing. I don't know what happened in this particular case, but putting fences on easements usually is not a thing unless the homeowners association says thou shalt not construct a fence on the easement.
I don't think they wanted anything in their easement.
So, you know, that being the case, if he had asked the surveyor to mark the easement, then he should have, not in addition to marking the property line, he should have staked the easement.
Well, see, because when I was reading it, we don't know exactly because he said three different things about what he was asked to do.
Yeah.
This goes back to like the first complaint, sloppy, just not being careful.
Yes, I think that's probably.
That's really the person's fault here. That's the thing that he might have done wrong. Maybe he's not incompetent, but this is what happens when when you take a small fee to do something. You're not careful.
A small fee, so I'm going to try to get by on the minimum that I can get by on. Yeah.
And the fence ends up in an easement. The homeowner, the person that hired you, has to pay a lot of money to move the fence.
Let me tell you, it is a lot of money when you want these things to put up be a privacy fence. It doesn't matter what it is. The fence companies come back and charge a whole lot. Probably should have gone to the surveyor and said, hey, Mr. Surveyor, you owe us for moving the fence.
Well, actually, money did change hands. He sort of was sorry that happened. He did. I didn't put that in here because that's not relevant to his
me is no different from the gentleman we just met with in this formal hearing. You know, we found him to be a violation of public safety. In my mind, this case basically says the same thing. Communication thing, and obviously it's a good thing.
It's the long and short.
Yeah, I mean, the text is here is
I didn't know how you felt. There seems to be, I won't say an epidemic, but probably something's always been there, and that people are getting, I don't know if lazy is the right word, but there are people that take great pride in what they do, and are very diligent, and then there's people either through length of doing it, or maybe the size of the job, or I don't know what it is, but they end up, this is what happens. The house always wins. It's just a matter of time before something like this happens.
Now, his letter of reprimand, the last or the stiffest letter prior to
reprimand means we know you did something wrong. You're lucky we didn't give it. Warning means we strongly suspect. Reprimands can come from the city. We never use reprimand letters because if it's that bad, there's usually a civil penalty.
Warn, reprimand, or penalize is the question.
I didn't put it in here, but you can consider the fact that he came clean on it, even though. But his reputation's damaged now.
Sure it is.
If you're careful on the front end, then you don't have this following you around now. So he's his own worst enemy. I mean, we can assess a penalty. I think maybe a warning might be enough.
Well, I tend
You won't do it again.
to agree with that. Just give him a warning, because I'm not sure that a penalty would do any more than what a warning would do. And he, like you said, he came clean on this thing. And he said, "Hey, I messed up. I paid for this." Let him know that we know.
We know, and everybody else knows.
Everybody else knows that, hey, this is the case.
Well, my greatest concern on penalty is we're a little thin on 100% justification. I mean, you know, it looks like something, it smells like something, it probably is something, but you can't 100% say it's what it is.
That's why.
I agree with Galen. I think warning is probably appropriate.
That's why it's 500. I rarely ever go under 1,000.
Yeah.
So that's an uncertain. Not really.
Yeah. Well, it is. I mean, it has, like I say,
Robert
I
has
mean,
his house.
Do what?
Robert has his house.
Said, what's opening right
but if you want to make that formal motion, then Galen?
I make the motion that we issue the respondent a letter of warning.
Okay, we have a motion and second. Letter of warning. Any further discussion? Call for question. All right. Okay, Rob, I think we're down to the last one.
Case.
Called the lunchtime case.
Yeah. It's easy. default. Since we're talking about lunch, default. 2012-02-133. The complaint alleges professional misconduct on the part of the respondent with possible violation of 62-18-116. In this case, the allegation rests on the fact that the respondent failed to pay for services rendered by the complainant, who was the, preparer, not preparation, preparer of the stormwater pollution prevention plans for the respondent's use. Respondent gets this so he can do what he was supposed to. After the complaint was filed, the respondent paid the complainant in full, and the complainant then notified the board in writing that he wishes to withdraw the complaint. And there's no complaint history with this respondent, so I can't just withdraw the complaint because it's up to the board to decide. It's the board's complaint, it's not anybody else's. So this was just a payment of services dispute, no allegations of misconduct. It's like he paid for it, and the complainant wishes to withdraw the complaint. So I submit to the board to issue a letter of caution to instruct the respondent to be more diligent in business dealings with other professionals and clients.
Well, if that's appropriate, let's do so.
I didn't want to just close it. I wanted to have some memorialization that his professional conduct is satisfying to somebody.
You know, if you ask somebody to do something, it's, you know, all are paid. It's just the way it is.
Eventually he did, but looks like he's been forgiven by the complainant.
I would say it just took the persuasion of a complaint to make it.
It's funny how that works, isn't it?
Hey, I recommend that we take your recommendation to issue a letter of caution.
Okay, we have a motion and a second. Further discussion? If not, call for the question. All in favor?
Aye.
Okay. Anything else at the moment, legally speaking, Mr. Herman?
Completes our case review.
All right, it's now 12:15. We will adjourn until approximately 1:15 or 1:30 in that vicinity when we get back from lunch. Yes, ma'am. I'm trying to do so much better. I'm trying to be so much better. Okay, it's now 1:42, and we're going to reconvene, and we will return to our new business agenda. And the first item on the new business agenda is a director's report, which everybody should have on their, whatever you call this thing, iPad, to review, and I'll turn it over to Ms. Donna.
Okay, the administrative office has hired a new employee, Dennis O'Brien, is permanent. And then we have one temporary employee to help us with the backlog of work. The notice for rulemaking hearing of professional conduct changes are in the Commissioner's office, awaiting approval to file with the Secretary of State's office.
Do we have a problem?
Well, I asked you.
Do we have an issue with that, Rob, or what's the deal?
This is the current process.
Okay.
I sent them up in October to legal, who sent it forward to the Commissioner's office at various levels, Assistant Commissioner, up to the Commissioner's office. After that, the Governor's office needs 2 weeks to look at them. And they eventually come back with permission for us to file amendments. And to be honest, I don't know where they are at the moment. I think they're either in the Commissioner's office or at the Governor's office. As soon as they come back, I will file, and I think that, did I tell you what the deadline was?
I think you said February 15th.
Okay, to hit our next board meeting, I have to have them filed by the 15th of February.
It's like 45 days prior or something of that nature.
45 days, is it 45 days? Plus 5, looking at, yeah. I I ciphered it out to where if we file it by February 15th or whatever the date is, we'll be good for the April meeting. I just haven't gotten back for approval yet. And this climate of money and everything, the governor's office wants to see everything we do, try to change regulations, and that's where it is.
And we're beginning to work on changes to the continuing education rules. It's an ongoing thing. And probably the regulatory boards that are in this building will be moved back into the David Crockett Tower in approximately June or July of this year, back down the street.
That's where you all used to be.
Yeah.
You moving back every day?
Yeah, we all are.
Everything above the 8th floor of this building is being worked on.
Yeah.
And they're done, I guess, they are.
I think they're finishing up.
I said they've been remodeling that building.
Yeah, top to bottom.
Oh, so they're gonna move
I don't know, do you
they're gonna
know
move y'all out.
the floor?
I don't know
Probably
what
on
floor we're
eighth.
going to be on yet.
We don't know yet.
But we'll have our 160. Did you ever have meetings in 160?
Yeah. Very rare, we're so small.
The conference room over there, it will be on the first floor, but on the opposite side, if you recall. I don't know.
I don't think Tim.
The only time we've
that
been over
Tim
there is
did.
when we met with the engineers.
Yeah,
Go in the front door and to the right.
yeah.
Well, now you'll go in the front door and to the left. It's behind where the guard station used to be, is what I've been told. It'll be on the opposite side, but it's all new and it has a built-in audio-video system, high-tech,
Yeah, it's supposed to be
conference
really nice.
calling,
We
and
have music there.
fancy,
They can read your mind.
digital, like, all kinds of good stuff.
Yeah.
Little broadcaster. Okay.
Coffee maker will be premium, and, it's good stuff.
There you go. Okay.
Correct.
So we can probably look forward to that probably by the August meeting, basically for us.
Hopefully.
Hopefully. Fingers crossed.
I heard that some things are ahead of schedule.
So where do we park if we go over there?
We can get you.
Space 18 behind.
There's a lot
Well,
of.
we can get you. I guess, I'm assuming we can get parking places in the back like we do now. I don't
Same
know.
process.
Yeah.
I will make a request about 2 weeks prior to the meeting, and they'll assign, if they have room, they will assign a parking spot. If not, you'll have to.
Yeah, because we used to try to reserve places and they wouldn't reserve them.
If it's warm, I'll walk in.
Yeah.
Well, you know, it's close to probably down here where we pay. In some places, I have to probably go and walk.
We'll do everything we can. We might even be able to get you, if worst case scenario, we might even be able to get some kind of temporary tag for the state lot. So worst case scenario is more like a block than.
I park way down behind the farmer's market.
Yeah, I used to just put.
Try not to do
Until I
that
got
to you.
disabled.
Try not to do that to you.
Okay, our FY 2010-2011 budget, our total expenditures were $177,084, total revenue, because that was not a renewal year,
Right.
$41,320. Our adjusted balance was $86,681, so we were in the black. 2011 and 12, we had $172,133 total expenditures. Our total revenue was $367,373. Our adjusted balance was $280,921. So that was a renewal year. Our budget plan expected for FY 2012-13, our budget plan expected was $178,300. Total expenditures as of November 2012 was $47,472. Total revenue was $21,154 as of November. Let's see. Land Surveyors Activity Report as of January 22nd, 2013. We have 825 active in-state land surveyors. We have 68 land surveyors in training. 42 inactive surveyors, 31 retired, and 335 active out of state.
That number going up or down?
It's up slightly.
1,300 licensees.
That's the total.
Yeah.
Well, the retired surveyors has increased, the LSITs has increased.
Yeah.
And In-state, out-of-state's increased just a little bit, although it's actually increased just a little bit.
Yeah.
Good.
And they'll increase after the regular season. If we have it, depending on who passes it. And that's just a little chart of our revenue and expenses patterns from FY 2007, 2008 forward.
All right, thank you very much, Donna, for that report. Do you have the conflict of interest
I do.
statements? We'll go ahead and sign those.
David sign this tomorrow.
David will be here tomorrow.
Yes, sir.
So we'll have all four of them. It'll be a better opportunity to discuss the rule changes. Four of them.
You also have the minutes, signature
Oh.
sheet while we're signing. Get some of these signatures out of the way. And Mr. Cole, what was the disposition of our certificates, our wall certificates? Like Donna said, did you say she?
Yeah, they don't have to be on, you said they have to be on the agenda because they're not voting. They're just signing.
So we got those to sign too?
Yeah,
Now, we can wait on those,
yeah.
if that's all right. And we'll continue to move forward. Okay, the next item on the agenda is to review current board policies. I don't know if everyone received those or not. Had time to look at them, but they are on our handy dandy little iPad here. It seems as though we have 19 board policies, which have been crafted from 1999 up to this year, right up to 2012. We crafted number 19 in our last meeting in 2012. I've read through them, and it appears that most of them still apply. A big majority of them are simply clarifications, which is good. We need to have those. But I want to thank you for compiling these for us, Donna, because this is something that we as board members need to have and know about. So, one, we don't go against what the policy says unless we change it, and two, we know this gives us another basis and background for doing what we do. So I don't know if y'all want to have any discussion on any of them in particular that you may have looked at. particular reason behind that, Rob? Like maybe you might have crafted
It
it?
looks like it's reading me written.
Well, I will say that it's not been placed on the website yet, and I think when it is, we may suffer a little bit of grief. Even though I think it's the proper thing that should be done.
Yep. Mr. Northcutt knows it got in there and never went away.
Which one is that?
10 years.
10 years.
No, let me get down to the 10-year one here.
Well, some of it have to do with how we tell ourselves we manage the board. Other stuff is for public consumption.
Yeah,
Do you ever use policies 3 and 4?
well, I wanted to speak to policy 4.
I'll look at that too.
But
Let me look at 10-year here.
it's very interesting. Policy 4 basically allows this board, which I was not aware of it as chairman until I received this and read it. It basically allows us as a board to, at our discretion and vote, to determine if we want to establish any continuing education credits for our activity as a board. Obviously, I wouldn't think there'd be an application to get so much continuing education, but in the normal workings of our board, such as the formal hearing and things of that nature, we could potentially have continuing education hours. I don't know that any of the members necessarily need those hours to meet their requirements, but we certainly have that ability to do that. It's good that we've been made aware of it, because as each of you know, we spend a lot of hours conducting board business, whether it's here or preparing, or whether we're at NCWES meeting or wherever it may be. So, and rightfully so, as Galen knows and found out more particularly this year, when we go to the tax convention, we end up getting a lot of questions. We talk about a lot of things, and so there's a lot of hours we spend that we could actually take and use, but you know, we go and attend and get our hours. I'm not implying that it would be an abuse of our position. It would be appropriate to do this if we so choose to. If at any given time any member wants to address that and have a vote or discussion on it or whatever for that qualification thing, we certainly can do that. And the chair would be glad to entertain that. And basically 3 and 4 are, one says you can vote to do it, and the other says how much. Basically, the way I read
I give credit for going to like the NCWES annual meeting.
it. You do?
Do you?
Well, generally, they have PDH sessions, and we actually get credit for those sessions.
Not just being there.
Yeah, no, not just attending.
I don't think that meetings outside of that apply to those policy statements, because it says the board meeting, so I think that applies to these meetings.
Well, we have, in these other meetings, they have continuing education
So you would need it.
presentations, so they actually
They-
provide us
they give
with a certificate and everything.
It would be redundant then.
Yeah.
They have certificates if they attend this.
If I don't have to draft this one.
Right.
If register to show up and sit through our meeting, we don't get credit.
Yeah, the difficulty would be establishing it as pre-qualified number of hours, because if you wrap up board business quickly, you all could go home, but if somebody came expecting to get 6 hours of credit, and you only were here for 4 hours,
Obviously, you don't get 4 hours.
right, you're not gonna get 6 hours, so, the difficulty
Talking
in
about CEs in general.
doing
Sure.
CE for board meetings is that it's hard to know exactly how long it's going to be.
Yep.
And I don't know if you all want to set requirements where you would have to, even if you finished what you would consider your business, had to continue talking for another 2 hours just to may establish and give credit to attendees to gather an audience.
Well, I appreciate that the board that invoked that particular policy was considerate of that specific issue, and that is something there that we could utilize if we so saw fit. So that's kind of, as Galen and I discussed one time, it's kind of like, somebody asks you a question and you're at break, at a continuing education presentation, when you continue to answer that question, you're not talking about the grandkids are mowing the yard. If it's a legitimate question, the fact that you miss 5 minutes of the presentation, to me, is not an issue as being a board member, because you're already giving more time and everything else to the profession, missing that 5 minutes. So I think there's merit to both sides there. Okay. Well, if nobody has anything on the policies, again, Donna, thank you very much for getting those, and I will certainly keep those with me if we have questions on them in the future. I guess that's the sort of thing that I do, as Sue would say. So that's real good. Appreciate that. Okay. The next item on the agenda is discuss the continuing education process, and I think that's more of just sort of a continuing clarification, Donna, basically.
Yeah. Because I don't know if everybody understands the way it's being done now. Because when the 2-year renewal went into effect, the law was changed to say 2-year renewal every odd year, but the rules weren't changed to say turning your hours every odd year with your renewal fee.
Right.
So the rules still say yearly. The law says every odd year. So everybody turns in their hours every year. And if they don't have enough hours for, say, 2012 and 2013, at the end of 2013, if they don't catch their hours up by the end of 13, when their license expires, they do not get a new license, even if they paid their money. They will not get a new license until they catch their hours up. So that's what we need to change the rule to jive with the law. Their license isn't taken away. They're not, threatened with, I'm gonna come get you and all that stuff. But they don't get a new license if they haven't met all the requirements at the end of their renewal period.
Right. Now, where do you currently stand?
And that's when they'll get a letter too saying, on some hours.
Right. Where do you currently stand on the registrants submitting continuing education for 2012?
Most of them do it. There's a few that, and I don't know how many, because I don't know by looking at the computer if they haven't met all the requirements until the renewal year. You know what I'm saying? But most of them turn them in yearly. I'd say more than that.
Nicole, as you remember at our last meeting, when we met upstairs, we discussed this very issue, and that was the annual versus the biennial scenario that we were looking at in changing the continuing education language.
Right. And if you look on your, I had Donna write up a little summary for you with some screenshots of our computer system on page 63 in your board notes. It shows you on page 63 and 64 how she's reporting it, how she's keeping track. What?
63 is a great example.
Lance Lingerfeld.
That's my son.
He's got no hours posted.
Yeah.
He does now. So, because I got those after this. But that's to show that he was a new licensee. He didn't have hours for that year until the end of 2012.
I think what she did, she gave us an example of each one of the
Yeah.
screens.
The next one, he has all his hours for 2012, so he's good for 12, but he doesn't have any carryover for 13. And the next one, he's got all his hours for 12 and has 2 hours carried over for 13. If you don't understand our system, we've been doing this since 1994.
Okay, on that first one there, on 64, top of the page, it says number of CE hours 14, and below it says carryover.
Because he had
hours.
some carryover that we added 2. I think he probably had, I don't know how many carryovers he had, but he turned in enough to meet the requirement with this carryover.
Okay. So he says it, and then when it says carryover, it says he has 15 hours.
Right.
What's the little slash 2?
2012.
Oh, okay, 2 is the 12.
Right.
When then the bottom.
Because it won't let us put, you can only put 4 characters there.
You there?
We'll probably have to change the reporting system for continuing education in the future so that you can see more
And probably
specifically.
we have our new system, it will be changed. Hopefully.
It will be changed. But it's not a very specific system, and it certainly doesn't allow for tracking an ethics course or something like that, and it doesn't have the reporting features that you might need if you were going to require an annual continuing education.
Oh, you even report if you lose hours.
Yes.
Oh, okay. Well, I get that every year then.
Yeah, you do.
Because I always
Because you
have.
can only carry over 15, up
Right.
to 15 per year.
I guess over the last 10 years, I've averaged 35 or 40 because of all the seminars.
So that's the reporting system currently. If you don't turn anything in, Donna, we wouldn't necessarily look at your license and know that you hadn't turned anything in for 2012 until 2013 came. And then you tried to renew, and you'd see that you didn't turn anything in 2012 or 2013,
Yeah, and then I
you
sent
wouldn't
them a
renew
letter,
then.
tell them how many they owed for 2012, finish that up, and then they owe so many for 2013.
So, if you have a biannual renewal that's best to tie the whole thing as one lump, like 30 hours instead of 2 15-hour
Yeah.
increments.
Correct. Every renewal period stands on its own.
Right.
Just by the time you renew, you gotta have this.
So, if they want to wait until December of 2013, God bless, go get 30 hours.
That'll be hard. We have enough that wait now to get 15 in December.
I know, yeah.
And when they go to 30, they'll really have a chore then.
Then they'll expire and owe late fees, I
And there will
assume.
be people that do that.
Oh, yeah. There's always somebody that'll fit into every mold.
I wanted you to understand it so that you at least had a
Yeah,
conceptual.
well, that's good. That's the first time I've seen this particular screen. So that's good. Well, I know she makes a statement here, Don, that says no licenses are revoked. They're just aren't renewed until the renewal requirements are met.
Right.
I guess that's true. We don't cancel the license.
Because I can't do anything like that.
Yeah.
All I can do is tell them.
Right. But as we've discussed recently, I think that as we get to renewal scenarios, if people are not sending their stuff in, then I think that we may begin to start filing complaints on it. Because, I mean, if you think about it, if you have a licensing window from January 1 of 2012 until December 31st of 2013, you have 730 some days to complete your requirement.
Yeah.
And then if you go beyond December 31st of 2013 on into the next year, you're in violation. You are in violation.
Yeah. Yeah, by that time you are.
And the only way we're going to get registrants' attention if they do that is to actually file a complaint against them.
See,
So
when
we can
they,
take action.
if I don't have all
Wouldn't
the
need to file a
hours,
complaint because their license would expire and they would not be able to do any land surveying The real trick would be is if they did a land surveying while their license is expired, then it's unlicensed conduct at $1,000 per
And see,
violation.
that's the thing that we've got to get the registrars to understand.
We can't remind them to keep up with their own. If they don't meet minimum requirements, their license becomes invalid. They still have it, but they can't use it.
Here's another thing. The law says their license expires December 31st of every odd year. It doesn't say if December 31st falls on a Monday or it falls on a Thursday, it expires. But if it's on Saturday, it doesn't expire until y'all come back to work. December 31st, no matter when it is, whether there's a holiday in there, whether we're here at work, you know, it doesn't matter. It's got to be, I got to have it by December 31st. And that's what they don't understand. They'll say, well, I mailed it right before Christmas. Well, I didn't get it.
You just got to figure it out. Get
Again,
your stuff in here before the
right
deadline.
responsibility.
But you wouldn't have to process a complaint because if somebody didn't want to renew their license.
Well, it's not a disciplinary offense.
Right.
If they don't keep up with their license, it's their problem.
Right.
It's not something we say, oh, you better not do that.
And if they decide they don't want to renew, then I'll ask them to send me a letter. Just all of that.
We send them reminders.
Send them a renewal notice.
Okay.
They get a renewal notice in October of their odd year. So they'll get one this October.
Okay, so that's 2.5 months, maybe almost 3 months
Right.
ago.
Now, a question. Since we're in this marvelous electronic world that we're in, are you able to communicate with most all of our registrars by email now?
Most of them, some of the older ones maybe not, but most of them.
Because the reason I ask that question is, in other states that I'm licensed in, very often I will get an email 2 weeks ahead of time of renewal. It just says, you know, your renewal's up whenever, and I get the email. So then that alerts me if I want to do it, you know, by mail or whatever it's
We don't
coming.
do that. We don't alert them of their.
We don't currently, but we will. And we're sort of in testing phases now to do it. We're moving towards a web-based licensing system where the licensees will input their own information, like their address information and that kind of stuff. So if they put their email address in there, then they can be notified of renewal requirements and also any rulemaking or any notice like that. We'll be able to do that for everyone who has an email address. A lot of the land surveyors don't even have email addresses recorded, so that one's a little further behind. I think some of the other boards have got home inspectors at probably 90% reported, and appraisers somewhere in the 80 to 90% reported with email addresses. But I think land surveyors is a little less than, because it is an older profession. A lot of the licensees just never turned in an email address, either initially or.
And we ask for an email address on the renewal notice when we get it, and most of them fill us out if they have it. If they don't, you know.
Okay.
And we just went to online renewal, so we're doing good there.
Yeah.
One thing I might say about the online renewal that I was very displeased with personally was the fee that the state adds. And the reason I say that is because other states I can renew online and there is no fee.
The reason there is a fee is because the credit card company charges it, and we don't have statutory authority to deduct the credit card fee from your licensing fees. You don't have an allocation for paying credit card companies. So essentially you're paying the credit card company for the convenience of using your credit card, but we can't take it out of your licensing fees.
Right.
You'd have to have statutory authority to allow something like that, and no, I don't disagree. That's something you'd have to get changed.
Well, that's fine. I
with
mean,
legislature.
that's good to know, because if someone asks me that question, you know, why y'all charging that $7 fee or whatever it
It's not something that, unfortunately, you could control it. It has to be changed legislatively.
is? What activity have you been seeing since that's been instated as far as fees? I guess.
Because all they do is fees on it right now.
Right.
I think we had a pretty good.
You have a fair amount?
Yeah.
Because a lot of people pay it just to keep from doing the stamp or anything else, just to get it done.
Yeah, we have pretty good turnout on that.
Because I know, like, particularly in North Carolina, they always give us the option of either doing it electronically or
Yeah, they can do that. They
paper
can
either
still,
way.
we have that.
But it's the same either way, the only
Yeah.
difference is the same, basically.
Yeah.
So eventually you'll be able to upload information to your license data system like communication or, whatever else a licensing may need to turn in. They'll be able to upload straight to our licensing system.
Okay. So I assume from that y'all are trying to get as paperless as possible too.
Yes.
So in order to have all these thick folders.
Yes, as much as possible. And eventually, hopefully, we'll be able to do some of that with the applications for land surveyors. You'll have less of the boxes of paper dirty or more digital, better quality copies of things to see, rather than somebody sending you a paper copy of something.
So with applications, how is, without computer-based testing in this area is, how are we going to receive those scores? I guess we're going to mail them to us?
They email them to us now.
Yeah, that right now is what they're planning.
Because now you can take the test on virtually any time you want instead of
Well, just to speak
Twice a year.
To speak to that briefly, they're going to go over that at the President's Board Assembly next week in Atlanta. Matter of fact, I would have known all about it if I hadn't got sick at the last meeting, but on the NCWS. But anyway, primarily, they're going to have four 2-month windows each year for the CBT FS exam. And a applicant will be able to take the examination. This is what they're suggesting, but it's up to each individual state board. One time in each window for a maximum of 3 times in the calendar year. So,
But you don't have to wait till the next cycle to take it.
yes, you do, according to what they're saying.
Because it seemed like you could take their test, and if you failed it, you could take it. You didn't have to wait 6 months to take it again.
Oh, you don't have to wait to the next cycle.
Right.
If that's what you're saying, there was the next 2-month window.
Yeah, you don't have to wait half a year to take it.
No. In other words, January, February, you'd have a testing window. March, there'd be no window, but April, May, you'd have another window.
Right.
So if you took it in February and failed it, you could come back in April and take it. And that's part of what we as a board have to address. And I would like to really put that discussion on hold until our next meeting, which will actually be in April.
It'll be after the interim.
Right, and I'll have more information to let you all know what they're saying, how they're going to handle it, and so forth, so we can react appropriately. Because it's going to change.
It's going to change how we
It's
take
going to change. It's
applications.
going to change how we do business.
Yeah.
Technically speaking, we virtually would have to potentially look at applications in October for people that will want to take it in January. So we have to look at that, and we'll have to discuss it in pretty good detail in April and come up with a plan of action so that we can start following suit. But part of this board president's meeting next week in Atlanta that I'm going to is going to discuss this very thing, and all the licensing boards will be there so that we'll get different opinions and so forth, to kind of see what everybody else is doing too. Everybody else is going to wear the same shoes. They're trying to get prepared. A lot of them, we're very lucky. We have very limited items statute-wise that we have to change. A lot of them have a whole chapter or something to do. They got a whole thing to do, so they're sort of in a panic. So we're in pretty good shape on that for the most part. So, but I'll get that information and I'll report back to the board with kind of what all the base details are. I mean, I know it's a 6-hour exam. It has 100 questions with 10 pretest items. I know all these kind of things about the exam, but
It's just sort of rumors about it. But
yeah. Well, no, they were going over some pretty good details on it. So I know a lot of things about it, but I thought I'd hold judgment on discussing it further until after this board president's meeting, so we can get hard details, because everything's finalized for it. It's ready to go.
Yep, in 2014, that's the way it's going to be.
And then,
Get a cease of
And
paper
then-
test.
and then in 2015, we're going to see the PS exam go that way also. So, you know, our proctor, Peter Messier, doing our examinations, is in 2014 going to lose the FS exam as far as proctoring. In 2015, he's going to lose the PS exam as far as proctoring. And he'll be down just to the state-specific test. And the next move there is, which is in the works right now, is to encourage as many states as possible to go CBT with the TS exam. So, but that's on down, you know, that's probably 17, 18, 2017, 2018. We're looking at that there.
So April and August meetings are critical.
Yeah. Like I said, we have to rechange our thinking, just as we've rechanged our thinking with our complaint reviews. Now we're going to have to rechange with our examination procedures. But I know, I have all confidence in the world that, you know, once we have the facts, we'll get it in a mold that we can all work with. It'll be awkward at first, as everything new is, but we'll get a hold of it. Okay. Anything else on the process or anything, Donna?
I have everything.
Okay. The next item on the agenda is we have several individuals that have submitted either continuing education or continuing education with questions, or there's been an issue when Donna has reviewed them as to whether or not they're appropriate. So there's varying things on each one of these. So we'll just move into them as they're on the iPad, if that's okay. It may not be the same order as on the agenda, but we will look at them on the iPad. And the first one on the iPad is Randall Orr. And it appears here that he has submitted some continuing education, and in doing so, Donna has replied to him on a particular item. It says continuing education submitted. The particular course is GIS on the go. It's not been pre-approved by the board, and a list of 3 or 4 items are attached. So, my first question, Donna, is does Mr. Orr have any additional hours?
I think he did send in additional hours,
Okay.
but he still wanted y'all to look at this and see if you would approve it.
Okay.
And I told him I'd have you look at it.
Okay. All right, this appears to be an 8-hour course that was presented in Kingsport, Tennessee at a Tennessee Geographic Information Conference.
It's got front and back stuff too.
Okay. It was in September 18, 2012. You can see the conference chairs are. And it looks like you sent some kind of syllabus.
I have the original here if you need it.
Blank can be, David. Well, I'm blank. Yeah, that's what I'm trying to
Every
figure out.
page?
Just blank page.
Every other page. Every page.
I was gonna turn this way so I can read it.
You can lock the rotation on your iPad so that it doesn't rotate automatically. I just changed the setting on mine so it stopped doing that.
That means getting out of what we're already doing here and go find it and block it. We get lost.
Yeah, we're gonna see.
Well,
Like an itches kids.
Share the screen.
Okay, well, the first thing I'd have to say about this,
The page,
I don't know what to think.
the page at the bottom.
All right, let's go back where I was at. Here we go. I'm gonna not touch this thing for a minute. The first thing I would say is he has claimed 8 hours. The certificate claims 8 hours. Yet, it started at 9, and they broke for lunch at 12, and they restarted at 1, and they adjourned at 4. Well, I'm not very smart, but 9 to 12 is 3, and 1 to 4 is 3, and that makes 6.
That's what I see.
So I'm not very smart about that. It also has from 2 to 2:30 a vendor open area, which means that they're looking at something the vendor's got. It also has from 10:30 to 11 a vendor open area. So those 2 times total up to another hour. Now we're down to 5 hours. We also have a 20-minute window where our local representative, Tony Shipley, has been politicking to the group. So that's a 20-minute area, which is a half an hour, so I'm at 5.5 right now.
4.5.
4.5?
4.5, yes.
Did it get to 4.5?
Yep.
I was at 6 and I lost 1, that made 5, right?
Yep.
Okay. 6 and lost 1's 5, and then I lost,
Another half hour,
well,
20 minutes or whatever you call it.
yeah, another half hour, so I'm at 5.5.
You were at 5, now you lost another half hour, you're at 4.5.
Really?
Yes, sir.
Well, thank you for helping me. I appreciate it. I need it. Okay, we're at 4.5. And I don't know how Rwanda ecological forecasting applies to the surveyor in any form or fashion. It's between 2:30 and 3 o'clock.
Yep, 230 and 250.
What's the one that's at 1 to 120? Isn't that also Rwanda ecological?
1 to 120.
Yeah.
Don't see that.
Page 83.
I'm scared to look at the page.
Right there it
Go-
is. Just
go
tap
two
the
pages
screen
over.
gently and it'll show you what page number it's from.
Oh, yeah, I'm on page 8.
Look ahead a couple. I'm just trying to look at it at the same time you are. Or maybe they're splitting rooms. Like
Oh, I see.
They're splitting rooms.
Okay, I understand.
Yeah, they're splitting rooms.
Yeah, I see
So
what
you
you're...
could attend any part of it and not necessarily all of it.
Mhm.
Yeah.
Oh, I get it. Multitasking.
Hmm.
So how do you know which part they attended?
Mhm.
Well, I don't question that there's potentially some merit in the course, but I think he's asking for our opinion. My opinion is 4 hours a day.
Okay.
That's my opinion. I don't know. Sue, what do you think?
Same thing.
Okay. Well, we have can we have a motion to that effect so we can notify the
reason?
the registrant?
Jim said something.
So move if it had been moved, and otherwise,
I'll second it.
must be good, there goes the fire engine.
There we go, fire engine said it's
Another
good.
fire put out.
Okay, all those in favor?
Aye.
Okay. So Donna, if you'll notify Mr. Orr
Okay.
that we feel like that it was due 4 hours of continuing education. Okay, the next one is Mr. James Snyder.
Mr. Sneeder.
It appears that he has submitted continuing education called Easements, Subdivision, and Land Use. HEC RTS Real-Time Stage and Flow Forecasting for Mill Creek, and Watershed Advisor Refresher Training. Okay? So let's see what these are.
Ones that he's questioning are the U.S. Corps of Engineers,
You're down at the bottom of the page, then. Oh. I'm just looking at this.
Yes.
Watershed. The last two certificates.
Is there a course summary somewhere?
Yes, indeed.
Okay. My recommendation would be that until Mr. Snyder submits the proper background information to support his intention that this course is appropriate, that this board not do anything. I find it interesting that they printed a date wrong on the certificate.
Bring it what?
That date wrong. On the license certificate for all the survey standards, the date is printed incorrect. I don't know. Very wrong. Pretty sure Bluegrass Engineering can tell regulation.
Yeah, I believe they are.
Yeah, RTC.
I saw someone submit a course taken on February 30th once. I had to say he wasn't there.
I bet when out of that.
He said he took a course on February 30th. I said he did not.
Probably not.
I probably agree with that statement.
I said you made this up.
January 54th.
Probably said, I wonder if the board will catch this.
Submitted it in April.
National Water Services, he must work for Hal.
Yeah.
Who was that?
This guy must work for Hal. What's the board think? Any conclusions, Mr. Stewart? Galen, what do you think? I don't think we have enough information
I don't either.
to recommend for or against.
I don't think so either. I'm not seeing it up here. That makes me want to think I can recommend either way on something like this.
Because I mean, a HEC-RAS study is an engineer design study for drainage and spring flow. So, you know, I don't know.
Pretty sure 20 PDHs.
It says it's given over 3 days. Actually, so you could have got 20 in 3 days.
Yeah, could have.
But Donna, if you'll, I think it's the pleasure of the board, if you'll send him an email or a letter, whichever is appropriate, and tell him he needs to provide background before we can make any kind of decision on this matter.
Do I have to make a motion to vote on tonight?
I would think we would, because we're not actually doing anything.
That's fine.
We're just giving you an update and let you know what to do to him, with him or whatever.
And on,
You could make a motion, require her to send her a letter.
Okay.
That's an affirmative vote.
You want to do that, Mr. Foster?
Motion so made.
Okay.
Second.
Okay, we've got a motion and a second. All in favor, say aye. Okay. All right, now, the next one is Jerry Taylor.
the only question I have about this one is that he's wanting credit for that article, but I don't know how many hours to give him.
Okay, Mr. Taylor is a professor at East Tennessee State University, as all of you know, and he has written a magazine article that was published in Professional Surveyor, and he himself is questioning how many hours that we would give him for that. The current continuing education rules basically indicates that an individual can satisfy the continuing education requirements under 0820-5-.05, paragraph 4, section B, which says authorship. I'm having trouble with words today. Authorship of published papers, articles, or books, and so forth. So this is what he has done. Atypically, I think what we've done is the individual has submitted a quantity of hours that it's taken them to do their preparation, whether it's a presentation or an article or whatever it is, and we basically granted them those hours if we didn't feel like that they were out of line. So, it looks like he has plenty of hours anyway, doesn't it?
Just take 4, I carried forward.
He didn't
That's
carry
40,
forward
carried 26.
because he can't carry over that many. I don't know how many he's got so far.
You can only carry 1 year's worth.
Right, 15.
Yeah.
15.
I would just, my recommendation would be that you just get back in touch with Dr. Taylor and tell him that he needs to provide the board with the number of hours that he's invested in this, and the board will review that and make a determination on it. I mean, if he says it took him 2 weeks to do it or whatever, and we feel like that's appropriate in order to craft that article, and we can grant that, but at the end of the day, like Galen said, he's only going to carry 15 over anyway. Whether we give him 200 hours, we can't carry 15 over.
Yeah.
Okay, we have a motion, Sue, for Donna to contact Dr. Taylor and get his quantity of hours. Okay, we got a second. Some further discussion? All in favor?
Aye.
Okay. All right, now let's see what's next. We're all on here.
Here's another one.
Okay.
This is the Arkansas Society. It's like our TAPs,
Okay.
but they're not approved. So I didn't
This
accept it.
gentleman's name is Ken Beckwith. And is he a Tennessee resident?
Yes, he lives in Atoka, Tennessee.
Atoka.
Or
Must be in West Tennessee.
yeah, Tipton County.
Tipton County, okay.
Okay, it appears that he has went to Arkansas Society of Professional Surveyors in Little Rock, and he's taken 5 courses. Well, I see 2 right off the bat that we can't approve. We can't approve anything on a vendor. And secondly, we can't approve attending the annual membership meeting because we don't allow that in our current continuing education. So there's 2 hours that are out.
Yep, I agree.
else that's an issue, right? We reported 17 hours, we're only kicking 2. I see. Do they give it, that membership meeting, they give that to him out there, but we don't? Okay, Gary can't do the evenings. Jeff Lucas. Okay, Jeff Lucas did the mock trial. Yeah, he does good seminars. I mean, they're all very much on the up and up. That would be my recommendation: is we deny the vendor hours and the attendance to the meeting hours.
Yep.
That'd be my recommendation
For a total of 15.
for a total of 15.
Still.
It's still fine, should be, unless you have an issue of carryover or something. I mean, this is for 12 anyway. Do we have a motion to that effect?
So moved.
Okay. Any further discussion? If not, call for the question. All in favor?
Aye.
Okay. So moved. Say no, Donna.
Well,
That meets our statute,
I'm sorry, I wasn't happy to write all that down. Which courses were specifically excluded?
so. The annual membership meeting and the vendor showcase.
I tried.
Because, I mean, clearly in the syllabus of the meeting, it says the vendor showcase, all they're doing is introducing the equipment. Okay. Next one on the agenda
Tommy
is
Young.
Mr. Tommy Young.
And when I sent him the letter telling him they weren't approved, he said that was okay, but he was really concerned about the Auburn one.
He's concerned incorrectly. This is Tommy, that's smart.
Yep.
Okay, Mr. Young has submitted 3 different courses, okay? I'm going to speak to the last one first, and the first one last. On the last course, he submitted a course that was presented by Auburn University, and for 6 hours. It was presented by Milton Denny. Milton Denny is a very good speaker and does an outstanding job. I'm very familiar personally with Auburn University's program, and it's a very good program as far as continuing education. So he's asking for 6 hours there. I do not have an issue personally with that because I'm familiar with the speaker and the program. Now, the middle item is Illinois Ethics and Professional Conduct. I have a little heartburn over that, but not near as much heartburn as I have over the first item, which is Illinois Statutes and Standards. I don't know of anything in their statutes and standards that basically parallels what we have.
I never have seen it, so I wouldn't have a clue.
Right. It does say that Milton Denny did present ethics and professional conduct, as well as statutes and standards. So, I mean, at the end of the day, I can go with the second item.
The 2 hours.
I just think that's just. He didn't know real long I touched something, boy, it was going wrong. It's crazy.
You're about to get there.
Wow, thank you, Jim. If I touch it even halfway wrong, it gets me.
Right there. List of
I understand that, okay. didn't send anything in on that Illinois statutes and standards, did he?
No.
Am I missing? Like I say, he was concerned about the Auburn course. Don't have an issue with that one. And I don't have an, you know, and I'm okay with the ethics and professional conduct taught me that being. I've had that course, and I don't have any issue with that. By our rules, I don't feel like that we can give him credit for his first course, which is 4 hours of Illinois statutes and standards. That's my thought.
I agree with your thought.
So, what do you think, Ms. Sue? Okay. So, we have a motion?
Motion so made.
Okay, we have a motion and a second. All those in favor?
8 hours?
Oh, we're gonna take those 4 hours off.
Or we're gonna do the 6 and the 2, right?
We're gonna do the 6 and 2.
Right.
But our motion basically is to not allow the 4 hours of Illinois statutes and standards, yeah. Because, you know, one, he didn't supply any kind of syllabus. Two, I don't know how we parallel those at all. That's kind of a little bit of a reach to a man. I mean, I just feel like that in general discussion that any laws or standards for any other state as far as continuing education should not be allowed for our state. Not that it's not informative and so forth and so on, but it's just because you have to do that. So anyway, call for the question. All in favor?
Aye.
All right.
The next one we have is Mary Young. I didn't get hers in time to get on it. Hers is another one where she took a West Virginia, I believe, side courses. And that, there's duplicates in there, so seems like.
Take a little time here and let y'all look through this and see what's going on. Dr. Clark is also an educator at East Tennessee State University. But she's now young, she was Clark. So.
There's nothing in the iPad on that, right?
I kept looking for it. We have to do this old fashioned way, Bill.
Have to earn it, too.
That's earning this.
But I will go with
Are you going to the,
He has not.
on the, oh, this today? Okay, I was going to ask you, do you want to go to Biloxi? Okay, I'm going to do that travel request. So, just want to make sure.
Yeah. That's a pretty informative thing to do. After last year's in Huntsville, I thought, you know, should have been going at least 15 years ago. But that is informative.
Wanted to make sure.
Yeah, I think Rob will tell you that too. They're very informative. But it got the attorney for engineers.
Oh, I've heard of him.
You know, the attorney for engineers?
Yes.
Okay.
Yeah, I could feel free to pay for him to go if you want.
Okay, it's now 3:04, so let's reconvene. The last item we were discussing was Dr. Young's teen education. I think my recommendation, Donna, is that you contact Dr. Young and have her to provide some type of syllabus for these hours. I don't have a great question with it, but at the same token, we have nothing to justify any kind of decision one way or another. So we need a motion on that.
So moved.
Second, those in favor, say aye.
Aye.
Okay. All right, that concludes, I think, unless there's any more on, concludes the continuing education questions from registrants and our administrative director relative to some of the types of education they ask. Okay, I'm going to take care of another item. I'm going to suspend new business, if it's all right with the members, and we're going to go to old business. And I'd like to continue our discussion on the possible licensing for photographers and GIS. That is just behind on your iPad, just behind the rules on continuing education chapter. What Donna has on the iPad are the requirements from the state of Virginia for licensing a land surveyor and or surveyor photogrammetrist. I spoke with Kate Norbish, who is their executive director, and she sent this information to me, and I think she indicated that they have 157 surveyor photogrammetrists licensed in the state of Virginia. More and more states are licensing photogrammetrists, primarily because of the obvious overlap of the things that we do as surveyors versus what photogrammetrists do. Obviously, the mapping portion of photogrammetry is some of the most basic technology that they do different than what a day-to-day surveyor would do. Yet, at the same token, there is a significant, in my opinion, there's a significant overlap of ground control and things of these natures that they actually do. To kind of see, I thought maybe I'd use Virginia as a good example because they're one of the more recent ones that have licensed surveyors, surveyor photogrammeters. This is an area, along with GIS, I have some other information on GIS that wasn't included on the iPad here, but these are two areas that I feel very strongly that our board should give some consideration to looking into for the possibility in the future of being able to craft some type of legislation that can be submitted by the Surveying Association or whomever, whether it be through the department or however that may be, to the legislature for possible licensure.
So, do we have their definition of photogrammetrist? The actual definition they have there? I don't see it.
They have that, Rob, and
I bet they do. But
she did not include it. I don't know if I have it in my paperwork here, but I will look and see. If I do, I'll be glad to give it to you. I know South Carolina, for example, they license photogrammetrists and also GIS individuals. GIS, in my mind, is becoming a large problem in my area because of the work product primarily that they're producing. They're now in the southern zone, yes.
Should be at the,
This will be their first southern zone. I think I have the answer.
this person will be at the end of the meeting.
Yes, Kate,
Yeah.
tall, sort of blonde-haired lady.
We might want to take a few minutes during the course of the days to talk to a state that actually does regulate this stuff. Might be informative.
Right, here is actually the definition. Let's see. The definition for approved photogrammetric survey experience. This is the definition for their experience. Right there. I had that, but I didn't include it in the stuff that I was sitting on. I apologize. This also assists, in my mind, particularly in protecting both our registrants, but more primarily protecting the general public in the state of Tennessee, where we have so many aerial photogrammetric firms that come in and work not only for the state of Tennessee, but for private individuals and companies, and they come in from other states. And I think that this would be a very good thing to help protect the public's safety and welfare relative to our profession, because it's a very obvious and smooth overlap and transition between the two professions. So
Would this be a species of a surveying license or a completely separate license?
well, it's handled two ways. In Virginia, it's handled as a species, as you phrased it, of a surveying license. In other words, it's a surveyor photogrammetrist. And in South Carolina, I think it's handled as a truly individual license. But I think Virginia is very indicative of the potential numbers base that we will be looking at if we looked into that particular venue for licensing. I'm in South Carolina license. I'm trying to remember. Swag method, I think, is about 125 per
Virginia license.
157.
So how many would be licensed in the state of Tennessee?
I would think somewhere in that zone. It's interesting. Photogrammetric surveyors are interesting because they're all over the United States, and you really don't know where they're coming from in the process.
And I agree with that. I lost some really good work to photograph. I mean, some really good work. And I thought there's no way that they can fly this thing and meet state standards, but they claimed they could.
How could they?
Huh?
Not being on the ground finding license.
Well, let me tell you what it had to deal with. It had to deal with doing what they call a 405 survey for designing and building instrument approaches into airports, into satellite airports like Nashville, Lebanon, the outlying rural airports. And what they were doing is that they were flying the areas off each end of the runways at these particular airports, and they were photographing everything coming in. They had the target set out on state plane coordinates, and said that they could get within 5/10 foot, what have you, and the FAA tower or the FAA said it's going to be right on. Okay, and I gave them a price. Look around. You don't have to be licensed to do a full-time survey because you're not tying anything to boundary or transferring title or anything like that. So I worked on beef I do, because I set all the control on the airport, and then I came back, did the Sunline Airport, went out 10 miles either end of the runway and located obstructions, like, you know, on GPS. And I got the Sunline and I went out and I located obstructions as we came in toward the airport, so we could determine, you know, the descent angle and everything. A lot of work, and a huge report to turn in. And I got paid handsomely for that. But when the photographer said, oh, we can do that for less than 1/5 of what you charge, I thought, holy mackerel. I said, there's no way that I can compete with something like this. And I said, there's no way that you can be that accurate. Oh, yeah, we're more accurate than that. And I said, how do you do that? And so that right there says, if you're going to do that here, I think you need to be licensed. So, and I think that there ought to be minimum standards that they have to meet, just like Category 1, 2, and 3, and 4 surveys. I think they need to meet that. If they can't meet that, then, you know, there's some other reason or some other place for their business to be as far as standards are concerned. So that really has given me some concern. That's been several years ago.
You know, that's the other side of the issue. Photogrammetrist in Tennessee is an unregulated profession. Yeah. And it affects the public.
It also affects the surveying profession.
Oh, yeah. And I think, you know, that's part of our charge, looking at the public.
I guess the good thing is they can't create plats.
No, they do.
They do create a plan.
Yes.
You would think they couldn't, but they do. I mean, you look at and go get what they call an ALP, it's an airport layout plan, and that's created by these photographers. I mean, I created the one I did in Kentucky, and I had 3 others lined up here. In fact, I've been asked to do some more work down in the Caribbean. One of the guys that goes down and does work down there, so he asked before Christmas to work with him. But that's beside the point. The thing is that we're actually on site with GPS and everything doing work and what have you. Photogrammetrist, and they're out there taking the work and no license.
So what is TAPS? They discuss.
You know, I don't know that TAPS has ever discussed that.
No, I don't.
It'd be nice to hear what they have to say.
Well, we can certainly bring it up. You know.
It would be interesting.
We can figure out from their discussion with them what the impact has been for the profession.
Well, you'll find that, you know, in our new standards that we just got approved, the remote sensing section is, I mean, it's dead on exactly what these folks are doing. So, I mean, you know, as far as, when, you know, you asked about definition, as far as definition, the interlap or overlap, whatever, is huge. It's way more than a lot of folks understand.
Wonder if there's got to be somebody that belongs to TAPS that is doing this or is doing this that already has a license with us.
What's that?
If we could locate that person, we could bring them.
Tuck out of Virginia probably.
Yeah, Bobby Tuck does. He's a licensed surveyor in Tennessee, and he's also a licensed photogrammetrist in Virginia and several other states.
It'd be interesting to have them come in and talk to them.
I'm sure Bobby for that.
Try to explore this issue. Another licensing scheme would be some heavy lifting. So we need to know as much as we can. We'll probably change the way the board looks. They'll probably have to add another board.
There's been a problem with adding you to the technical advice.
First, we need to know what it is.
What is the separate part of it?
Desktop appraisals that are done, or drive-by appraisals where a lot of the information is gathered through public data sources or a lot of information. Not firsthand, I went inside the house and looked through the rear room of the house kind of information. Essentially, the scope of work is just less. It's a different scope of work, the same licensing requirements, the same professional standards apply, but the scope of work is different. Not every it's the same, I'm sure not every license survey is not, it's the exact same level of work.
And I don't know, I'll be glad to talk to Barbara, but I don't know that there's any significant resistance in the program. Because so many states are doing this.
We need to know what it is, how you do that.
Can I make a recommendation for it?
Yes, ma'am.
You might want to require or request that a letter be sent to Bobby Tubb asking him if he would attend the next commission meeting on behalf of CAPS to discuss what the licensing of a photogrammetrist entails and, you know, a perspective on it from somebody in a professional organization. Made a motion to have Donna send him a letter to invite him, and then if he agrees to it, put him on the agenda, then you have an official.
I think, well,
I mean, you can't require him to do it, but you could request it.
yeah, we could, but if we do that, we also probably need to ask the president of TAPS to be here at the same time and advise him what we're doing and monitor it.
Absolutely. We need to have people here.
So
So they know what we're doing, and know what they're doing too.
you might want to make that in the form of, say, a motion, and request Donna do that for you.
Just try to stay ahead of the curve as things change, and try to stay ahead instead of trying to catch up. So if we could try to do that.
By April, you should also have, you will have attended the meeting, so then it might be a better time to discuss it also. You'll have somebody's.
Well, Mr. Chairman, under the advice of Nicole, I think I would make this motion. We invite Mr. Tubb and Mr. Foreman to come down and attend the next board meeting and discuss with us the potential licensure of photographers in Tennessee.
Well, I would like to, Bobby's a personal friend of mine, and I don't have any problem picking the telephone number, but just asking if he was interested before we send the letter. I'm sure. He would tell me straight up,
Let's say if he says no, then
then we.
maybe we'll
do
let
another
it be,
soul.
because he might not.
Yeah. But I feel strongly.
Knowing him, I think he would.
Well, if he was available, he probably.
And I've worked with him before,
Yeah.
and on some of these very same things.
I've worked with him for 30 years.
I was just recommending it so that for sure it ended up on the agenda. That's all. If that's what you want to discuss, that you have the opportunity to make sure it happens on the agenda. I'd hate for it to come around to April and then not have been done.
Well, I made the motion, maybe it ought to be predicated on
Well, I would, since I know him, I think that it would come across, not come to me, but it would just come across better if we received a phone call and told him what we was thinking about.
that's fine.
And then a letter follow up by Donna would, I think that would be more than fine.
Yeah, I don't have a problem.
More than fine.
We can have the board authorized to make that contact on his behalf. Just so it doesn't look like a random board member contact.
Yes, there you go.
I mean, if that would be okay, I won't stay within, if you're going the right direction, I won't stay within the rules, But I think that, this is.
You have the board's authority to do this on their behalf, it would be better.
Yeah.
Because we don't like, or shouldn't have board members out just acting on their own.
Right. It's no different than when we request to have to do the education. We got the board approval, and Mr. Request. Same thing. That's the way it's going to be.
Well, let's start our investigation. Let's sooner we start, the sooner we can try to do something. Technology's evolved, and it's all across the board in every profession.
Will you mind, since you've not actually formally made a motion, would you mind to amend it to the effect that I am the board would like to approve the contact and then if he is willing to follow up with your knowledge. If that's okay. Motion second. All in favor? I know it seems as though we're tackling a whole lot, but we do also have GIS on there, and that's something that I actually would like to discuss, Gail, when we go to Biloxi, Gary Thompson, because they have that in North Carolina, and also Dean Deacons, because it's in South Carolina. I'd like to kind of take advantage of being there to discuss that a little bit more. I mean, I know that opens up a big plate. That's a bigger basket of people.
That's the beauty of these meetings. They're there.
Right.
Member boards get together and try to figure out how to handle stuff. It's just a spread.
I like to really do that.
Okay.
Just so
That
it's
was
that,
exploratory.
just
That
so
was
it's,
totally exploratory right now. I think the other one is getting ready to move forward.
ultimately, it'll be up to the legislator to decide whether or not it's appropriate to license them. The board can make a recommendation to the legislature, but ultimately it's legislative authority to license or not license.
I look at it because it expands the purview of our board, but more importantly, it protects the residents, and more importantly, it protects the public.
I've seen people licensed in other states, especially borders. It's a pretty good indication of what they're doing in civil line level. Certainly. It's going to come into the city. Not even make it.
No, not yet.
All right, well, let's move on then. I added an item to the agenda earlier today, and that item is HAPS Convention Roundtable. We have been notified that we're going to be on the Saturday morning HAPS speaking again, entitled "This is that Board Land Surveyors Roundtable," and all of us are invited to attend. And they have given us 1 hour in their meeting schedule, which has been submitted for PDHs. We hope that Donna will approve that.
I think you've already been approved.
I don't know if y'all remember, but in August of last year, we were sent a query. I don't know if I forwarded that to you or not. Aaron Sands sent me that query. I'm pretty sure I did because he actually copied it at that time. He copied it to Jack. Galen did not see it. That's my fault. I should have sent it to him. But he's aware of it. So anyway, the reason I put it on our agenda was I wanted to be open and forthright about it to the point that, I think we need some direction from Rob. There's subjects that we should or shouldn't touch. Transparency is wonderful, but obviously there's certain things that maybe we shouldn't talk about. So I wanted some direction from you in that regard. The young man that's handling the convention speakers and so forth basically doesn't really have a defined format for us. He's going to kind of leave it up to us. The scenario is going to be, we're going to be in a very large room, sitting at the front of the room, all with microphones, and there'll be multiple microphones throughout the room, and there'll be probably 300, 350 people in there. So, obviously, we can't answer everybody's question. Would be time. So, we need to kind of formulate some sort of approach to, do we speak to the audience and speak about a handful of things, whoever's going to speak, and then do we field a few questions? And if we field some questions, which ones do we want to stay away from? That's probably my greatest concern.
What do you anticipate as far as problematic type question?
I think one of the questions is going to deal with the 10-year rule.
Yeah.
In fact, we may have 101 questions in the 10-year rule.
Yeah.
We've got a policy with it now. What we've
So
decided.
that's another reason why, I know that's kind of reversed, but that's why I wanted it on that website. So, you know, reason being is if it gets on that website, we may field a few calls beforehand and be better prepared based on what the calls come in than going in cold turkey. And somebody says, by the way, I heard y'all did a policy the other day. What's the deal on this?
Well, I know a lot of people think just because they've been out doing it for 10 years, they should be able to get a license, but we've already developed a policy.
Is it just you attending this Lingerfeld?
Pardon me?
Is it just you attending this round?
No, it's the entire board.
Yeah, not all of us can go meet.
I think
So
that
she shows
might
up.
be a public meeting,
It is a public meeting.
which is not exposed on our website.
Well, that's why we're discussing it, because we have ample opportunity time-wise to do so.
That's April? Okay.
No, it's March.
March, excuse me.
It's March the 9th.
March the
Maybe.
Where is it?
Murfreesboro Embassy Suites.
Okay.
Sue, you have that.
I think you have to do a public meeting notice, Donna. Put it on the website, and you'll have to attend. You'll have to do
Yeah, she's
minutes.
on the agenda
Okay.
with the rest of us.
Okay.
At what time?
It's at 9 o'clock in the morning.
Public meeting. I think it's okay that you hold a public meeting somewhere else, probably, but I think you have to have the same rules.
That's what I'm saying, that's why we're bringing, that's why I'm discussing. I want to make sure that we don't do something wrong.
That's why I'm pitching that out there. So Donna's gonna have to get travel approval. She's gonna Murfreesboro. Well, then you may have to either expect, if you're gonna eat the expense yourself, then that's okay, but if you're not, then it's all up to you then.
I probably will, because
And Rob, I sort of want to invite you, I don't know that you were in that visiting, but I certainly want to invite you.
Check and see. Available.
It's a 1 hour window, it's from 9 to 10 basically on Saturday morning.
I can be there. I'll be.
Saturday, can you tell me the date?
March 9th.
March 9th. Am I invited?
Certainly.
Have to get something.
Pays your money and you take your chances.
Well, I didn't agree to participate with the
Well,
sport without knowing that I had to do some work.
You would honestly be surprised that when you go to a tax meeting and there's 350 people there, how many of those people don't have any idea that you're on board? Now, a lot of people do, I mean, friends,
Yeah,
long-time
right.
associates,
Don't
things
think
of
it's
that
on,
nature.
but
you
there
know.
are some.
Their tax board of directors, they know, but so many of the attendees don't. I mean, that's not important that they know, but, you know, that's part of this scenario is for, you know, us to be up front and say, I've seen that guy here, he's on the board. You know, I mean, that type of thing. But at the same token, try to give them some things. Well, for example, like what I talked about earlier, you know, privilege and responsibility and things that, you know, that type of thing. Just sort of fill in some blanks. That's why I want to kind of throw it out, between now and then, once we get everything all squared away with what we're supposed to do, we may come up with a few ideas and maybe we want to speak on a few of those ideas.
Okay, just touching, you said request of, the public meeting notice, something a good one, and revised on the website. If they ask questions, it happens to me a lot too, because I'm a real estate appraiser, and then I have required continuing education, and I've had to speak at different functions. So I certainly understand the position you're in when you go to a thing, how people want to ambush you with questions. That happens to me a lot also. If they ask you about complaints, which naturally they probably will, I kind of tie that kind of information back to my high school dating history. No dates, no numbers. Just no specific names, no specific. Don't tie it to anyone. Don't describe it to them in detail if they can figure out, hey, that's Bob Smith over in, I don't know where, Tennessee. Just generic it out so that you don't, because you never know who's in the room, and you don't want to hurt somebody's feelings, or it's not a public forum for whatever. But if they want to read about it, all disciplinary actions posted to our website. So
like I say, I mean, it's more kind of putting a face with a name and letting the registrants that are there know that our meetings are open. They're always welcome to any of our meetings. The meetings are posted on the website. This type of thing. If they have questions, no matter how simple, they can submit them to Donna. We'll get them an answer if they don't want to attend the meeting or whatever. Those kind of things. I'm sure there's a lot of the registrants that don't know that they can pay their fee, on the internet. They may not even know that. Things such as the continuing education. In the even year, you still have to submit your continuing education. There may be just a lot of things in general that a lot of them don't really know.
A lot of them don't realize they pay their money every odd year. Some of them pay it every odd year, and some of them pay it every even year. Because I have refunded some, like here recently.
and I just assume, just to get it out there, just assume you're all paying your own ways to go to this meeting, or do you need the state to pay for
They'll
the
pay
way?
their anyway.
Well, I just was checking.
Except for me.
I don't know if Miss Braley's gonna want to do that, or
I probably still that hour and I'm gonna go. No. I want to come when the board, that tax board meets. What day is that, Friday or Saturday?
That's Thursday morning at 8 o'clock.
okay. So they're not paying you to be there, and they're not paying your travel expenses. You're just going there as volunteers.
Yeah.
Okay.
Thursday morning at 8 o'clock.
And
How
I
long does that
think
last?
2 hours.
I'm not coming back. It's not used to me staying all day.
Well, that's Thursday, and
I don't need
this
to
thing is
get
on
in.
Saturday.
Yeah, I'm coming. I don't need.
But yeah, I want just to kind of bring in that sort of information.
Okay.
Make sure we're okay. And the vice president who's in charge of the commission he's indicated to me that he's hopeful that this will be very well received.
We used to do it
And then maybe we can do it again. I know in North Carolina at their convention, they normally have, right after their lunch, and they have a luncheon on one particular day, usually Friday, I think. They have like an hour and a half session right after lunch. Folks come and go, some of them hang around after lunch, and they discuss things and ask questions. The director over there, Andrew Ritter, he usually stands up and gives a 3-4 minute spiel as to the condition of the board, the number of licensees, and then he lets the chairman say something, and they address any member questions. I found it in other states, but I can't believe it.
Please. Oh, every year. Years and years and years.
tomorrow. So on tomorrow's agenda, we will, let me look at the schedule here.
Talk about rules and finish your
Yes,
applications.
we will come in the morning at 9 and begin our discussion about our continuing education rules. We have a gentleman that's going to be here at 9:30 to speak to us, and once he concludes his business, we will try to go ahead and go back to applications and include those, and we'll make every effort to.
David will be here. We'll get
Dave-
this signed tomorrow.
Yeah, David will be here tomorrow. We'll sign the placards and all that stuff tomorrow.
Okay.
And so we'll try to shoot for target time of sometime around lunchish of concluding tomorrow. That's all right, everybody.
Well, we're doing pretty good on these rules as far as crafting them, so that won't take too much time.
Yeah, we're getting down to, on the continuing education, we're getting down to some pretty nitty-gritty stuff. Because, you know, we've not made a decision on the number of hours, and we've not made a decision about, really formally about how many for who and that type of thing. And I say that relative to older surveyors and things of that nature. So we're down to some good stuff on that, on the continuing education, I think.
Yeah, I took a look at it. We got a lot of red in there now.
Yeah. Yeah.
There's a lot of red. There's some strike through, so we're doing good.
Yeah, I think that where we're at is a pretty good place on it.
We'll get some input from the professional society.
To be honest with you, I'm very disappointed in that. I sent a email to Benny Mormon in.
I think they'd be interested in this.
I would have thought so. I've heard some verbal interest, but I haven't seen anything written.
You know, this is how we get it ready for public hearing. Instead of everybody showing up day of and then
Right.
having an eruption of opinion.
Anyway, I sent an email right after our last meeting because the board authorized me to do that within the next day or two thereafter. I have it here someplace, but it currently eludes me. Here it is. I sent the email November the 5th, 2012, and respectfully requested that they get some comments from TAPS back to us by January the 18th, 2013 for our February meeting, and as of date today, we have not received anything. So I'm a little bit disappointed in that, but
Well, with all due respect, we're just going to move ahead.
right, we're going to continue, but we will certainly let them know in our March meeting that they've not done so.
I just would rather not be surprised at the hearing.
Right.
That's why we asked them. But, you know, maybe they're okay with letting us do it. It's not like they don't know about it.
Right. Well, we'll touch base with them at the board, at their board of directors meeting when we make our report, and kind of see where that stands.
I think we're gonna try to start getting a representative here at our board meetings too. Because if the TAPS representative was here listening to us tomorrow, we talk about these, at least somebody there would know.
Okay.
We'll start tomorrow.
Okay, Ms. Donna, you can turn the TV off. You can still look at the application.
That's everything.
Okay.
Harvest, we take
That
it.
work?